Some cases, the others are relying on it. Now, we filed the vacation of stay in these specific 3 matters. So otherwise, Lordship can simply keep it on another day, subject to the hearing here. That is the other way it can be done.
Would say that the registry to verify and list.
I am so grateful. That is enough, Lord. I'm so
Mr. And call it.
I'm grateful.
Additional advocate.
Lordship, I'm senior advocate.
Senior, that is senior counsel assisted by
Miss N. Menon. N. Menon.
and Menon. Then the counsel for the respondents. Respondents.
We are the
You are for
we are the respondents.
respondents. Commits that the analogous matters are being listed for hearing in court number 5. Listed before. Prested matter may be listed before the applicable bench.
We did try to inform the other side, but it seems they couldn't get informed. That's,
You informed.
we will tell them.
Having next para, having considered that the similar matters are being taken up in court number 5, from registry to verify list and list accordingly.
I'm so deeply obliged, grateful.
Wait, I beg to mention item number 2, my lord.
2.
It may be taken up after vacation, my lord.
Why? It's a motion, notice was not issued. Notice has not been
Item
issued.
number 2, my lord. After
Yes,
vacation, my lord.
it's a motion, notice has not been
Yes,
issued.
the comment is there, my lord.
Okay, on the prayer of Mr. Boiragi,
We Buddha, my lord.
you are not for petitioner.
We Buddha, my lord. I am also there, my lord.
Your name is not there.
Not there, my lord. That's why I am citing the corrupt, my lord.
So and so learned counsel appearing on behalf of Mr. P. Boiragi. No, on the prayer of Mr. So and so learned counsel appearing on behalf of Mr. P. Boiragi, learned counsel for the this matter after 3 weeks.
May I please, your lordship, item number 6 of today's list, my lord.
Yes,
And in this case, the respondent has filed an affidavit. I will go file to reply, my lord. So let it be come after due vacation.
on the prayer of Miss M.S. A. Bujar Burwa,
Yes, my lord.
learned counsel for the petitioner, list this matter after 2 weeks. So as to enable her to file a
Master.
Maybe I did to mention listing a motion matter, my lord. Motion matter, my lord. Listing for motion matter, my lord. Regarding the post of the Gaubra, my lord. I am
Huh?
selected, my lord. I was selected, my lord.
Have you filed?
Yes, already filed, my lord.
It will be listed. It's all motion day. It will be listed. You don't have to mention.
My lord, I beg to mention item number 32, my lord.
What next, my lord?
Hmm?
What next, my lord?
It will be listed if it is filed. New matter,
The new matter, my lord.
it will be listed. It's all for motion day. It's all motion day. It's a motion week. It will be listed.
Item 32, my lord.
32.
Yes, my lord.
Yes.
Some instruction was awaited, my lord, from my client, my lord. Let it come after vacation.
On the prayer, Mr. Answer Malan, counsel for the list this matter after 3 weeks.
May I please, your lordship? Lordship, with the consent of the other side, beg to mention item number 38, lordship.
38.
38. Lordship, conducting counsel, Mr. F. Khan is not well today, lordship.
Who?
F. Firoz Khan, lordship. I'm on behalf of Firoz Khan, lordship. A. Menon.
Mr. So-and-so, learned counsel for the learned counsel appearing on behalf of Mr. F. Khan, learned counsel for the petitioner.
Lordship, any date may be fixed on after being
On the ground of the leading counsel, Mr. F. Khan, being
A. Menon.
unwell. Come on, leave this matter after 2 weeks.
Obliged, lordship.
May it please your lordship, I beg to mention item 24.
24.
Lordship,
Yes.
we could not obtain instruction from our client.
Hmm.
So lordship, we need further 4 weeks time to file affidavit.
You are for respondent.
Yes, no petition.
Affidavit in reply.
Yes, lordship.
List this matter after 2 weeks. As spread by MS so-and-so, learned counsel for the petitioner for filing the
J. Deka on behalf of Disciplinary.
affidavit in reply. Yes.
Lordship, I will mention item number 15. Item number 15.
15.
Yes.
Yes.
Lordship, my senior is out of station currently. And we have filed already the additional affidavit. We have already filed the additional affidavit.
So
So right now the senior is out of station.
15, item 15.
Yes, item 15.
on the prayer of Mr. So-and-so learned counsel. On the ground that his senior, Mr. P.K. Basu, yes, learned counsel was petitioner in the Mr. List this matter after 3 weeks.
Maybe also. I victim item number 1 of today's list. Item number 1 of today's list, Lordship.
Yes,
Matter will be examined for today, Lordship, because we need to file our additional affidavit, my lord, but we could not take instruction from my client.
2022, it's listed for motion, what's there?
Yes, Lordship, because direction was there to file our additional affidavit to my lord, but
On the prayer of Mr.
M. Hawk.
M. Hawk, learned counsel for the petitioner. For the 3 weeks time is granted to file additional affidavit.
I'm only.
May I please, Your Lordship? It's regarding item number 27.
Hmm.
With the consent of other side, my lord. Matter may come up after vacation, my lord.
Rahul, okay. Mr. On the prayer of Mr.
PJ Fukan,
P.J. Fukan,
standing.
standing counsel, Guwahati University. List this matter after 4 weeks.
Most of them.
Yes.
Lordship, compassionate appointment, my lord. The
Yes.
issue here, my lord, is under consideration before the division bench.
Hmm.
And the next date is fixed in the first week of June, my lord. The
What
issue,
is the issue?
issue is that, my lord, the balance service period as per office memorandum, my lord, it should be 3 years of balance period, my lord. And that was, my lord, declared unconstitutional by this honorable court, by the single bench, my lord, which has been challenged by the government before the division bench is pending. My lord.
Balance period of 3 years.
3 years, my lord.
Heard Mr. So-and-so, learned counsel for the petitioner.
M. Ali.
And
I'm for the elementary education part.
Mr. P.N. Sharma, learned standing counsel, elementary education.
Lordship, I'm for resident number 2, 3, and 6, your Lordship. For resident number 2, 3, and 6.
I'm not hearing.
And so-and-so, and also heard so-and-so, and so-and-so. Next period, it is stated at the bar that the issue regarding requirement of balance 3 years.
Remaining 3 years. Minimum 3 years of service.
No. Regarding minimum 3 balance 3 years of service for claiming appointment on personal ground is pending before the division bench. In view of that, list these matters as agreed to by learned counsel for the parties. List this matter, the disposal of the writ
My lord,
appeal,
the second week of
writ appeal,
writ appeal 51/2024.
51 of 20. It should be, Mr. This should be listed after the disposal of the.
My lord, that is fixed on first week of June.
Right, that will be,
It may be fixed on second week of June.
no, that cannot be. Same thing, will you make a mention
Lordship.
after this? We said after the disposal of the writ application.
Alright.
After disposal of the.
Maybe leadership.
Yes.
You want to do with liberty, my lord.
What liberty?
Subsequent development is there, my lord.
Heard Mr. So-and-so, learned
Yes, sir, Ahmed.
H.R. Ahmed, learned counsel for the petitioner. No. Mr. H.R. Ahmed, learned counsel for the petitioner, submits that he has an instruction to withdraw this with petitioner with the liberty to file. PN, Mr. PN.
Lordship.
Sharma.
I am for respondent number 1, 4, and 6.
No, learned standing counsel for elementary education for the respondent is present. In view of the petition instance, dismissed. Is withdraw. With the liberty aspect.
May please, Your Lord. Lordship, petitioner praying for compassionate appointment, Lordship. Lordship, DLC has already recommended, Lordship,
In page number 20, Lordship. Page number 20, Lordship, column 2, Lordship, paragraph 2, Lordship, Mary, Lordship.
Where's the rejection?
Lordship, rejection is state commission, Lordship, page number 34, Lordship.
Committee.
SLC, Lordship,
Page,
34, Lordship,
yes.
34, serial number 34, Lordship.
Hmm.
Not
Not qualified
qualified
grade
for
three post.
grade 3 post.
So-
But Lordship, petitioner is higher secondary parts, Lordship. I don't know, Lordship, what is the,
You don't know.
grade 3 graduate, Lordship. Not Lordship, it is, higher secondary pass, Lordship.
No, according to them, the grade three is for, you must have the graduate degree.
No,
Graduate,
no, Lordship. 12 pass is the Lordship qualification. 12 pass.
he knows, we don't know.
12 pass is the Lordship. I'm not, Lordship,
Where's
I
the
am
rule?
satisfied. Lordship.
Lordship, so far, the entire new advertisement, Lordship, for grade 3 post, Lordship.
Forget about this grade three, what is the rule?
Yeah, no.
When you are saying that it is, one must have the degree.
Yes, Lordship, the new advertisement, which is sought for grade 3 post, Lordship, large numbers of grade 3 posts.
Sir, why not concerned? It is, depend on the advertisement to advertisement.
Yes, Lordship.
Grade three, from where you are saying?
No,
You
grade
just
3
cannot
post,
tell.
Lordship, it is graduate, Lordship.
So where?
No.
No, in every advertisement, it appears.
Sir, we're not concerned about advertisement, we're concerned about the rule.
No, Lordship, it is pertaining to the PNRD department, Lordship.
So,
So now, Lordship, this case is so far on the basis on the respondent state.
you are a state, you tell us.
Yes,
What is
Lordship.
the rule?
Lord-
It requires that the
No.
graduation would be a minimum education qualification for grade three.
Lordship, on behalf of SLC, Lordship, my submission is some different, Lordship, here in this case. My submission is that, Lordship, the father of the petitioner was died on 2015, Lordship. Now it is on 2025, Lordship. Now, Lordship, Lordship,
No.
it is not Debabrov Tiwari, it is very
Okay,
clear,
forget
Lordship.
about it, Forget about it.
No,
I'm-
Debabrov Tiwari is very clear.
Sir, I am conscious about that.
Uh,
Thereafter, you have modified, you have issued a new notification.
no, Lordship.
You have issued a new
No,
notice.
yes,
on the basis of Tiwari.
notification was issued, Lordship. And
Now, the rejection is on the ground that the petitioner doesn't have the requisite qualification,
yes, Lordship.
or he is not qualified for the grade three post. So I'm just asking simple, where is the rule which requires that for appointment to the post of grade three?
I will furnish, Lordship. I will furnish on this.
It's 2024.
24, yes.
Motion.
Now it is 25. Lordship.
So
No, I will furnish, Lordship. No, even, Lordship, no extra copy was given to me. No.
Lordship, page number 24, Lordship, the DLC recommends to kindly, Lordship, page number 24, Lordship. Lordship, column 6, Lordship, last 4, Lordship, last one, Mayor, Lordship. All required documents to the duly submitted, vacancy available, falls under all norms.
What
And
it is?
in next,
where is it?
Lordship,
Please?
Lordship, page number 23.
24.
Column 6, Lordship. And 7, Lordship, names of rejected applicant does not arise. Reason for rejection does not arise, Lordship.
All required documents are duly submitted, vacancy available and falls under all norms. Where is your name?
Roman Gogo 4, Lordship.
Field
Last
number?
one, Lordship, 4. Roman Gogol. Last one,
Roman Gogoi.
Roman. Reason for rejection does not arise, Lordship. DLC receipt, comment, Lordship. After scrutiny, Lordship, the DLC recommended the name of the petitioner.
It's okay, DLC, but assuming that you are not qualified, then how can your case be considered?
Yes.
For a time being, for a moment, we accept that it is graduate. Require education qualification is graduation.
Lordship.
In
Lordship,
that case,
I have to satisfy Lordship.
admittedly, you are
High secondary pass,
12 pass,
12 pass,
not graduate.
not casual. Yes.
If you file affidavit saying that
Lordship, Lordship.
this is.
They have to furnish the extra copy, Lordship, first. Extra copy was not furnished, has not furnished.
Other day I told you, don't make take a ground of not furnishing extra copies.
No, extra, Lordship.
Is the state so poor?
No, no, Lordship, but it is the, this is the, it is the,
No, I
Tradition,
understand, but
yes.
if wrong, you can not make a mention that you could not find that. This is a vague, very, very vague excuse.
no, now, Lordship, it is.
Not Mr. So and
Yes.
so, learned counsel for the petitioner. Next para. Matter relates to appointment on compassionate grounds in the post of grade 3 list of the state level
Lordship.
scrutiny committee.
No, SLC, state level committee for compassionate appointment.
State level committee for compassionate appointment has rejected the case of the petitioner on the ground that the petitioner doesn't have the requisite qualification of graduate for the post of grade 3.
Yes.
List of. It is the contention of Mr. So-and-so, learned counsel for the petitioner, that for the education qualification is higher secondary
High secondary.
and not graduate. Therefore, the rejection, the ground of rejection is not sustainable. Please stop. On the other hand, Mr. J.K. Goswami, learned additional senior government advocate, submits that the requisite qualification is graduate for grade 3 post. Mr. However, on a pointed query by this court that to the pointed query by this court to show any rule which requires the education graduation for appointment to the post of or recruitment to the post of grade 3 post. Mr. Goswami could not show any rule, rather he made a vain attempt to rely on some of the some advertisements which stated to have been issued, where it shows the requirement of the education qualification to be of education qualification to be graduation for the post for recruitment to the post of grade 3. Having considered the submissions of learned additional senior government advocate to be vague, but that 3 weeks time is granted to the learned state council to file affidavit. This notes. File affidavit clearly stating the recruitment rule in support of his submission, rather than rather than the advertisement that have been issued. Understood?
Lordship, post is for tax collector, Lordship. Post is for tax collector.
Just after 3.
Deeply.
May please your lordships.
Yes.
Case relates to appointment of commissioner ground, my lord.
Name.
The husband of the petitioner died on 29/5/2016, Lord says,
Yes.
and she applied 27/7/2016, my lord. But nothing has been done. Being aggrieved, she approached this honorable court, my lord. And my learned friend filed one affidavit, my lord. In
Yes.
this affidavit, my lord, he stated that
Page 29, my lord.
It's not there. Affidavit is not there. Yes. Borrow
what he said.
affidavit.
Page given 27, he gave it.
29,
29 page.
page 29.
It's nothing what is.
No affidavit, Lord.
There's no affidavit also. No office note, no affidavit.
My lord, may I give?
Already
No,
did it.
no. No, but
Not on record.
Anyway, what is your strength?
Stain is, my lord,
He's
he is
not entitled.
underqualified, my lord.
Huh?
Underqualified.
she passed class 9, my lord.
Hmm.
And my learned friend, my lord, he mentioned in para 4 that the district scrutiny committee scrutinized application necessary documents and all particulars submitted by Srimati Rina Boro and other applicants were strict adherence to the guidelines of the office memorandum 2015, my lord. But in 15, my lord, para 19, it is stated that where a widow is appointed on compassionate ground to grateful post, she will be exempted from the requirement educational qualification. Because after death of the husband, the wife will suffer a lot. That is why it is mentioned in the memorandum
When your husband
15,
died, 2016.
died 2016, my lord, having
So-
4 3 minor children, my lord.
If the widow is appointed, no education qualification. Grade 4.
So it is stated in the
In the office memorandum.
yes,
In
my
the
lord,
scheme.
government memorandum and
The scheme
yes, my lord. That is
which you are relying.
yes, he relied. My lord.
Which memorandum you are also relying.
19.
2019.
My lord,
May I submit, my lord?
No, have you not annexed?
Oh,
Which policy?
no, he stated, my lord, he did not mention.
let the affidavit be on record, my lord. Thereafter, let them file reply.
No, I'll not file reply because he stated that his district level scrutiny committee followed the guidelines, my lord, 1/6/2015.
When is the decision? There was any decision? Have you annexed the decision of
Yes,
the
my lord.
district?
Minutes of the district level committee of Buxar district for
Because he
appointment on.
set aside the district level committee and allow me to.
You have the minutes.
Affidavit is not on record. I mean, heard MSK, they learn council for the.
My lord, Wednesday, my lord.
After vacation.
No, not after vacation, Wednesday. I'll I'll call I'll
Mr.
prepare for
Yes.
calling the yes.
Yes, sir. Abba.
Wednesday.
Mr. Rabba, the understanding
Not
for
again.
PTC.
Sorry,
Yes.
Baba.
Convinced that he has filed
Please don't mind, huh?
as addition, filed the additional affidavit by furnishing the copy to the land council for the.
Those are local.
Fix this better on
Wednesday,
Wednesday.
Land council. Yes. Acknowledge this.
Wednesday হলে কি মানে 9 কিয় না থাকা 9 না থাকা
Yeah, Jenny.
হবো দিয়া কি
And
হবো
then it's not mentioned.
সবটা
There's
বেশি
no-
শুনবো পারা নাই না
not the appeals, okay.
Toshik will kindly call for the affidavit.
Just.
Yes, I will.
The copy, the additional, the affidavit in opposition is not placed with the record. Is not placed with the register to verify. And this according.
Wednesday, madam. When?
Let the registry verify. Thereafter only should be listed.
Huh?
I'm actually listening. Compassionate appointment, my lord.
Yes.
Already, my lord, P for 2024, my lord. A bunch of cases is disposed of by the coordinated bench, my lord.
Yes.
And my case is covered with this.
Yes.
Yes, sir.
It is so.
Saying what?
My lord,
Saying what?
saying what in para 7, 9, and 10, my lord. Pending. 7, 9, and 10.
You are challenging the new notification.
Yes, my lord. But my lord, coordinate bench without interfering the notification, OM, my lord, 18/9/2024, my lord. All the cases is disposed of with the direction to the state respondent, my lord, to consider the matter, those cases pending before the SLC, my lord, in terms of the prevailing government notification, OM, my lord. 7, 9, and 10. my lord.
Why not? It is exactly not covered, why not? Each cases has to be decided on its own merit. This is a malot, though that this notification issued by
Just a minute. Yes.
Malot, this judgment, Malot, now I have seen the paragraph 7. I have come to learn that all each and every cases will have to be decided in its own merit.
Yeah.
Hearing petitioner died in 1998. Now is for 27 years has gone. And the petitioner at that time, he was just underage, 16 years. So 16 years, he cannot claim for compassionate appointment. The Supreme Court on the Ketena, judgment is there, Supreme Court says, today I'm not feeling well. Compassionate appointment is not a mode of appointment. It is on the basis of ballot scheme. Scheme is not a rule. So government has issued this scheme, my lord, to read about a certain financial crisis immediately after death of the incumbent. So here 1998
No,
he
no.
died.
No,
How
sir.
compassionate appointment can be given?
In this case also, the issue is you have decided by the notification 18/9/2024 that no further
Appointment
claim
of
of appointment on compensation ground relying on the earlier policy shall be considered or admitted or accepted. Then court has, without interfering your policy, on the basis of your the submission of learned advocate general, it decided. Nowhere it says that will be considered by the authority. It clearly says all relevant laws,
Yes,
whatever
yes,
notifications
authorities,
should be considered.
yes, on its own merit.
Yes, similar.
So
They
Lordship,
are also saying that particularly in this case,
he died
this
in
case has been recommended by DLC in 12/3/2024.
24. How they DLC can recommend
There
appellate?
you take a call.
That is the wrong.
That
that
is
is
your office.
Yeah, office, I know well, my lord. Because
take
in
action, that is-
That is your
1990,
department. That is your
when a
authority.
person, yes, department may do wrong, my
No,
lord.
no, that's why I'm saying we'll,
mean,
we'll pass the same order. This covers. There's no there's no distinction.
No, no, my lord.
Those, all your things will be taken care of. You read the entire direction.
Only my learned friend going through the only para 7. That's why I may not like your submission.
No, no, my lord, this,
The all
And last
so
one
and
is
so
that
are to
your
be
court-
decided
the learned
as
friend is
follows.
Not appear before the court.
In view of the
That's why
consent
my-
of the
if
learned
ignore
counsel,
that-
all the writ petitions that are pending as on today, 03/04/2025, in the Guwahati High, which have put to challenge the impugn or OM so and so are to be decided as follows. All the applications so and so submitted by so and so shall be considered and disposed of by so and so on merit by taking into laid down by the state government for and the judgment on the Supreme Court and the High Court. You will have to decide.
Yeah, the Supreme Court says when Devabhat Tiwari, he with the lapse about 2 years.
Sir, that's why I'm saying you decide. It says, you read para 9. Please read para 9
my lord,
of
I
this
don't have
judgment.
to-
I have given that you return the order.
So let me have the go through it, my lord, let it be.
No, no, no.
Day after
It
tomorrow.
clearly says, read para 9.
Day after tomorrow, my lord.
Sir, please read para 9.
In view of the consent of the learned counsel for the parties, all the petitions are pending on as of today.
That are pending as on today.
The Guwahati High Court,
It doesn't say all the writ petition in the
which
in
have
that
to
case.
put challenge the office member of so are to be decided as follows. All the application for compulsory appointment submitted by the petitioner shall be considered and disposed of by the concerned BLC, SLC on merit by taking into consideration the various guidelines prior to 1/4/2017 laid down by the state government for compulsory appointment. The judgments of the Honorable Supreme Court and the High Court. Consequently, the rejection of all compulsory appointments by the DLC, SLC, which have been put to Celine, are pending in the Guwahati High Court as on 3/4/2025 are set aside. The entire process for considering the various applications for compulsory appointment and the decision of taken in each case by the concerned authority should be completed within a period of 6 months from the date of receipt of the certified copy of this order. This is the chairman, to the DLC and the uneducated chief secretary of the government also, who is the chairman of DLC, if the matter pertains to SLC. It is made clear that a review of the concerned parties, the High Court has not gone into the merits of any of the petitioner case that are being disposed of by the by this order, and as such, the application for professional appointment should be disposed of by the concerned authorities or merit as they deem fit and proper. Let that will not be disposed of, and I understand. Let the dispose of, the authority will decide.
Same thing. That's what
Maybe,
this
maybe,
is.
maybe DLC recommended. Actually, my lord, a Supreme Court in Katana decision has changed, my lord.
I'm,
The scheme only is the scheme where the.
sir, I'm conscious of it.
Yes, yes, lordship, well known, my lord. That's why, my lord, I am submitting here in 1998. There may not be any, my lord, grievances.
You decide that. You decide that. There is clearly provided, para 9, direction has been given. All right. Yes, then, how many? All these
Only one
matters,
petition.
only one matter,
Oh, yes,
7,
8. I think
8. What about 9?
9.
9 is different.
I'm not.
Okay. 8, huh? Not Mr.
A.M. Ahmed.
Huh?
A.M. Ahmed.
A. Ahmed, learned constitution. And also had Mr. Learned additional senior government advocate for the respondents. Next,
I'm taking you know, hold on, okay. No, I'm taking you. To the government, I was here. Okay. Come on, huh? Come on, no, I'm going to continue. Yes, you put it okay. Okay, you decide to go on for the party. Yes, you go to the okay. So you just have to remind people to have to go to the I'm going to have it. It what I agree with you.
By filing this writ petition, the petitioner has put to challenge the office memorandum dated 18/09/2024. Where it is? Office memorandum,
PS 35.
issued by the Commissioner and Secretary to the Government of Assam, Personal Department. Whereby it is decided that no cases for appointment on competent ground to the family members of the state government employees who had died in harness or retired prematurely on being declared permanently incapacitated in the service or missing and whose whereabouts is not known prior to the 31/08/2017 shall be entertained by any administrative authority administrative department, public authority for any reasons whatsoever, nor shall be placed before SLC or DLCs for the combination of candidate for appointment of competent ground. Next step. The case of the petitioner is that his father, Lakshmishwar Chutia, was an employee in the Bogamu PH Ayurvedic Demaji, who had died in harness on 08/09/1998. Mr. At the time of the death of his father, the petitioner was minor, and after attaining the age of majority, he approached the authorities for appointment on competent ground in terms of the guidelines. But office memorandum, it is 0106/2015. The district level committee, Demaji, guide its meeting dated 12/03/2024. Has examined and recommended the name of the petitioner for appointment on consistent ground. Mr.
Page 33.
Accordingly, the minutes of the DLC was forwarded on 20/03/2024 by recommending the name of the petitioner along with how many? What is that recommendation?
Page 33. Page 33, serial number 3. A middle person 1, serial number 1, Suraj Kumar Sutia.
Hmm.
Page 33, middle person.
Huh?
Page 33, middle person. Suraj Kumar Sutia.
How many persons were recommended? 1, 2,
Remarks column.
3.
Page 33, remarks column.
Hmm. Not relevant, yeah. Which clearly indicates the proposal for appointment of the petitioner for on compensatory grounds against the available vacant grade 4 post in the office of the Joint Director of Health Services, Demand. Mr. French learned concentrated semester before when the matter was pending for consideration by state level committee for appointment on compulsory ground. No, of the recommendation of the district level committee for appointment and compulsory ground to the rest petition. The include office memorandum dated 18/09/2024 has been issued. Which deprives the petitioner of consideration for appointment on compulsory ground. However, during the pendency, no, not how, he commits that. During the pendency of this, no, he submits that. Now this court in the case of Abdul Qadir Boxi versus State of Assam. In writ petition 342 of 2025. and other batch of writ petitions has disposed of the, they has directed the respondent authorities to consider the applications for provisional appointment. Therefore, the by the order that, this is the 0304/2020. Therefore, the case of the above order is surely covers the case of the present petitioner. And as such, similar relief may be provided to the present petition. Next paragraph, Mr. Petition to just, additional senior government booking. After vehemently opposing the case of the writ petition. Initially vehemently opposing the writ petition. Has submitted the in view of the order of this court. Order dated 03/04/2025. The writ petition can be disposed of by providing similar relief. Next step. Having considered the submissions of my consent for the petition, and only consent for the parties and on and having perused the order dated 03/04/2025, passed in 342 public 2025 and other batch of writ petition by this court. I am of the considered view that the order in the writ petition being dated Supra covers the case of the petitioner, as the challenge made in this writ petition is also in the notification dated 1809.
18/9/2024.
09/2020. Next paragraph. In respectful agreement and as a judicial discipline, this it is the petitioner is also provided with the similar order. Is provided in the order dated so and so. Accordingly, this writ petition is disposed of. Okay. No. Accordingly, as agreed to by the consent of the parties, writ petition is disposed of. With a direction to the respondent authorities. Which are as follows. There are 9 Roman 1, 2, 10 and 11. That's all.
Publish.
Obliged. Yeah, huh?
My please, Lordship.
Yes,
Well, in this case, we have filed an application for amendment of the REACH application. And inadvertently, the impugn order has not been annexed in this REACH application.
withdraw and file afresh.
My lord, we have no objection, my lord.
We have filed an application for amendment.
My lord, we have no objection.
With the amendment.
Yes, my lord, with the amendment, my lord.
So what is the?
So let them file the amendment petition, my lord, and thereafter the motion may be heard, my lord.
No, we have filed an amendment petition.
Amended, I mean to say amended writ petition. After the amendment is allowed, let them file the amended writ petition, my lord.
All right, after it should have been allowed.
Yes, my lord.
I will file an amended petition, no problem. I will file an amended petition.
Obviously, when what we allowed them.
No problem.
Heard Mr.
Yes,
A.
Judge.
Dasgupta, that is senior counsel, assisted by
Ms. B. Das.
so and so for applicant public writ petitioner. And Mr.
BK Singh for all the respondents.
Casing for opposite for all the learned counsel for the respondents. Next paragraph. By filing this application, the petitioners
Yes,
have
sir.
sought for, have applied for amendment of the connected writ petition being WPC 6565 of 2024. What are the amendments? Which are the amendments you are saying?
Page 8 of the amendment application.
Page 8.
Oh, yes, please.
Following of the next paragraph, following of the amendments sought in this application. This, no? Then you write page 8, huh? A, B, C, D, huh? Right? Next one. Having considered the submissions of learned counsel to the senior counsel to the applicants, public petition, and prayer for amendment. Has not been objected to by Mr. So-and-so, learned counsel for the respondents, come on, huh? Come on. This application is allowed. Just accordingly. The amendment sought for as mentioned here in the is allowed. Application instance disposed of. In view of the application in view of the other past so. The petition, counsel for the petitioners to file amended writ petition, amended public counsel with writ petition. Yes.
Obliged, my lord.
Yes.
Petitioner is seeking the area, the outstanding area matter and as well as the retirement benefits.
Yes.
Now what has happened, my lord?
We have to take instruction also.
Like notice this. Or instruction available?
No, we can take instruction.
But the petitioner was initially he was removed from the service, my lord.
Have you filed additional affidavit?
Yes, we have.
Huh?
We have filed. Saying that the Cement Corporation of India is
India is what?
It's under the government, my lord.
Government of India.
Government of India.
You are for Union of India.
No, no,
It's for
I'm from
cement
234 Cement Corporation. Bukaran Cement.
You are for Union of India.
Union of India.
Or Mr. So and so, learned counsel for the petitioner. This writ petition has been, this petition is instituted. That a writ petition praying for a direction to provide the retirement benefits within bracket, gratuity and provident fund, bracket plus. Along with other entitled emoluments. And also to provide areas with respect to the revision of pay from January 2006 to the date of termination. I.e. 13/12/2010.
No, it is removal, my lord.
Removal.
Removal.
You have said termination.
Yes. It wrongly.
Removal.
It's
Issue
terminated.
notice to the respondents. Since Mr.
Lordship,
You are for
Mr. J. Roy,
for respondent number,
that's one 234.
who is for one? You are one.
One lordship.
MS, no, since MS
RDD.
RDB and the CGC appears for respondent number. And Mr.
BP Sharma for J. Roy.
for
BP
J.
Sharma.
Leonard Senior Counsel
J. Roy Senior Counsel.
for respondent number 2, 3, and 4. Enters appearance and accepts notice on behalf of all the respondents. All the respondents.
No, 234, Lordship.
Yes. 1, 2, 3, 4.
No, he is for 234.
I said
Yes.
both of them are appearing for all.
Yes. Both of them are given.
Is there any other?
No.
No formal notice. However, extra copy with respondents. List of 4 weeks. Issue notice, returning of 4 weeks.
After man.
4 weeks.
Obliged. Extra copies will give away.
Yes.
My lord, they are questioning as to how the B.Ed degree was obtained, my lord. Now we have explained the position, my lord. Now at this stage, I'll pray for a notice on the writ petition as well as on the interim prayer, my lord.
You have been terminated or what?
My lord.
Have you been terminated?
No. My lord, we were provincialized in 2015.
A departmental proceeding.
Yes.
What happened?
So
I mean-
notice has been issued, Lordship. So cause notice has been issued to them, Lordship. Now against the so cause notice, Lordship. They have approached this.
No, it's of 2020.
24.
24 also.
24 is also there.
Heard Mr. Ken Chodu, the senior counsel assisted by MS and Mohan counsel for the petition. Challenge in this writ petition is to the initiation of, is to the so cause notice dated 26/06/2020 as well as 15/6/2020. Initiating deferment proceedings against the petition. Issue notice to the respondents. Returnable by 4 weeks. Next paragraph. Since Mr. A.R. Tabilda, and counsel for the, all the respondents,
That's it.
standing counsel,
No, that's it. One and standing council, 1 and 2.
standing counsel for
Higher education department.
higher education
Higher
department. Enters appearance and accept notice on behalf of all.
1 and 2. 1 and 2.
No, 1 and 2, no formal notice will be sent over. Extra copy promised to the council for the petition. Who else are there? 3 and 4.
Yes, sir.
Magad University. The counsel to the petitioners to take steps to establish a notice upon respondent number 3 and 4. Various steps as well as details.
I'm also praying for a notice on this stay, Miller, because the Magadha University statute clearly explains the position that they have not taken note. Page 62.
Issue notice to the respondents on entry prayer also. List after 4 weeks.
Yes.
Steps within 3 days. Madam, steps within 3 days.
Yes. Same. Deep.
Idris Ali.
12,
He's
yes.
also not doctor.
Same, Miller.
But he's
No, the same. The issue
Yes,
is
his
regarding
name is
Miller
not-
BA.
Okay. No, his name is not shown as doctor.
Oh, yes.
Same.
One is an
No,
assistant.
this, notice same date.
Same.
Okay.
Deep.
Same order. But find out.
May I please? Lordship, this is compassionate appointment, my lord. It is covered case, my lord, similar to item number 8, my lord.
Item number 8.
Yes, my lord, similar. to-
Lordship, may peruse page 11.
11.
Page 11, Your Lordship.
Hmm.
Para 11.
Yes.
Petitioner number 8 had approached before Honorable High Court
While disposing of the
in 2007, whereupon Honorable High Court by order dated
for the company in terms of the guideline in the Achut Ranjan bus and so on.
21/1/2000, while disposing, directed
Yes,
that
yes.
it needs to be placed as per in that terms.
Yes.
So, whether the same had been placed or not. Because if it has been placed and considered, this particular the order dated, order which my friend is referring to.
Well, after this, what happened?
There, my lord, no considered, my lord. There, my lord, I challenge the impugned notification, my lord. Office memorandum 18.
No, after this or direction, order of 21/01/2008, what happened?
No considered, my lord.
When your,
Because it cannot be so. Order dated in 2008, Your Lordship.
you obtain instruction?
Yes.
Lordship, direction may be given if,
No,
considered, my lord, no need to-
there is already direction of this court
Yes, my lord.
as per the Achut Ranjan.
Hmm.
Whether they have considered or not, according to you, you have, it has not been considered. All right.
Lordship, there are 10 writ petitioner, my lord.
Huh?
There are 10 writ petitioner, my lord.
Where?
In this writ petition, my lord.
This should not come in bulk because individual facts and circumstances are different.
Where are 10 petitions?
10 writ petitioner, my lord.
No, that's why we then you said, and at para 11, you said this court has disposed of the matter directed in respect to process the claim of the petitioner.
Yes, my lord.
It's only one petition in respect to one petitioner.
Lordship,
It's in respect of one petitioner or 10 petitioners?
One.
10 writ petitioner. my lord.
Presently, in the earlier in 2008,
No, my lord, one writ petition.
then why you club this together?
Lordship, here my issue is the same, my
Appointment
lord.
is individual.
Lordship, here is the issue is the same, my lord. Lordship, in this petition, my lord, I challenge the impugn notification, my lord. For this impugn notification, my lord, the DLC have not considered.
More so, Your Lordship,
This is
that
clearly covered,
page
my lord.
28 and 29.
Hmm.
Page 28 and 29. What it says that in pursuance of additional District Commissioner Hailakandi letter under reference, I am directed to request you. So that particular communication has been made by DEO Hailakandi.
Hmm.
But that particular based on which this instruction, this communication was made has not been annexed to. So to that aspect also I have to seek the necessary instruction. So page 28 and 29, the letter
There is a
referring to which they have, the DEO has made the communication or IS.
Why you have joined together?
Hold the writ petitioner, my lord, challenge the imping notification, my lord.
So this has not been interfered with, but then direction has been given. Have you got the 3-4 order? Do you have the 0304 order?
Yes, that I have gone through, your lordship. So
No,
this pertains to those matters which has not been attended or is subjudiced, your
You
lordship.
said
But
once,
since
if
clear-
it is, you consider, will provide the same relief. You consider if it had been considered, rejected it.
Yes,
Again,
my lord.
that is, this case has been considered, so we reject.
Yes, my lord. Same.
Because we're not passing any, we have not issued any mandamus.
Yes,
It's only for consideration. In terms of the relevant notifications, judgment of the Supreme Court and the High Court, right? Consider, verify and everything is provided in that case.
Yes, sir.
All right.
It's up to you, but I wanted that page 28, 29, based upon which letter that concerned officials had sought
No,
for.
it's all right, but
Yes.
then he has challenged your order 18/9/2024. That has not been interfered with, right? But then direction has been issued to consider, that's all. If their cases have been rejected, you should reject, nothing to be considered. All right,
Otherwise, in respect to petitioners, your lordship, except that particular, that in para 11, your lordship. Except that on the other petitioners, they will be entitled to this,
Yes, sir.
because they are,
no, it's okay.
yes,
Let
yes.
us not complicate it. Petitioner one or whoever, it relates to, whoever is relates to para 11 will not say anything on this. If you find, what you have to consider? Suppose his case has been considered and rejected. They are not saying that it has been
Yes,
rejected.
yes, yes. That meant.
They are saying that pendency, without consideration, this a notification has been issued. Therefore, same line will provide you. Huh? You just take the facts, but then give it to. You just take the facts. Hard, Mr.
H.L. Ashkar.
HR,
H.L. Ashkar.
HA,
H.L. Ashkar.
Learned Counsel for the Petitioner. And also heard Mr.
1, 4 and 6 lords.
P.N. Sharma, Standing Counsel,
Elementary education.
Elementary Education. And
I vote 2, 3, and 5.
2, 3, and 5. Mr. Dury,
2, 3, and 5.
P. Dury,
B.
B. Dury, yes.
Dury.
But the next one, a challenge made in this petition is to the office memorandum dated 18/09/2024, issued by the Commissioner and Secretary of the Government of Assam, Personal Department, wherever. A decision has been taken that no process for appointment on compulsory ground to the family members of the state government employees who died in harness prior to 31/03/2017 shall be entertained. Next paragraph. The petitioner, 10 in numbers, claims for appointment on compulsory ground. Who, what there?
7 or Q, 7 or?
Whose
Huh?
family relative. Brother, public husband.
Seven.
have died in
সাত নম্বৰ petitioner টো
the different, on the
এইটো,
different.
সাত নম্বৰটো একোৱেই দিয়া নাই।
The
এইটো কেনেকৈ কৰা?
service particulars of the next paragraph. This is government employees along with their date of death and date of application for appointment and constituent ground are extracted here in under. Para 3 in the box, box column. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, Next heading. It is the contention of the petition. Petitioners. That your case has been, all the cases have been recommended.
No, my lord. Verification was done, my lord, but due to this office memorandum, my lord, the meeting was not called.
Contention that verification for consideration for appointment on completed ground have already been carried out. Completion, however, due to issuance of the impugn notification, impugn office memorandum, the memorandum 1809/2021.
Lordship,
Respondent authorities have denied their right of appointment on the completed ground. Mr. Next paragraph. Learned counsel for the parties submitted that the coordinate bench of this court by order dated 03/04/2025 in writ petition so and so, you may cover no, and batch of writ petition involving the similar methods as disposed of the methods and directed the respondent authorities to consider a case of
এইটো মই চাইছো।
without interfering with
আপোনাৰ এতিয়া চাওক,
impugn
আপোনাৰ এইটো
ordinance
2029 এইটো 2029 হাতত ক্লোজ
they
কিন্তু
have
আজিলৈকে প্লেচ নকৰাকৈ এইটো নাথাকে। আপুনি এইটো চেলেঞ্জ কৰি আহিব লাগে। ইয়াৰ বেনিফিট আপুনি তাত কেনেকৈ পাব?
order dated 03/04
এইটো কৰাৰ ওপৰত বেছ কৰিব
Obviously,
দিছে,
yes,
এইটো দিয়া নাই না।
present petitioner. Next paragraph. Having considered submissions of law also for the parties. Also considering the having perused the order dated 03/04 passed in WPC so and so and other batch of writ petitions. I'm of the view that the order dated 03/04/2025 covers the case of the present petitions. Accordingly, with respectful agreement and as a judicial discipline, and also as consented and agreed to by learned counsel for the party. This writ petition is disposed of by providing the similar relief as on that. That there are two era 9 of the order. You give it to the petition disposed.
Lordship, just one.
Let us not make complicated. Yes, whether merit, unmerit, whether they are entitled, not entitled, whatever. What they are saying is simply their cases have been verified, right? And during the before any decision could be taken, this order has been issued, therefore their case will not be considered. Therefore, their challenge is 18/9/2024. So that has not been interfered with, and certain direction has been issued on the similar matters. So nothing to go into the merit.
What I wanted to highlight is, Your Lordship, that petitioner number 6 and 8, with respect to them, order is there in 2007, 2008, and 2009. Then with respect to petitioner number 7, 9, and 10, he has not made any, he has not made any statement, neither he has annexed.
Thank you.
At least their application should have been annexed.
We'll see.
Yes.
You decide whatever is there.
Most of them.
My pleasure. The
Not
discontent.
Mr. So and so. You should notice.
That's it.
Learned counsel for the petitioner. This is an application for application. No, this petition is filed alleging willful disobedience of the judgment and order dated 25/06/2024, passed in WPC number 443 of 2018, 2008, and WPC number 4273 of 2016. Mr. Issue notice returnable by 4 weeks. Land counsel for the petitioners to take its steps for service of notice. How many respondents?
Four respondents.
Respondent. Okay. Service of notice upon response by the start of so and so, so and so. Within 3 days from today. List after 4 weeks.
Pleasure.
So already also I have taken steps, but in the order, Lordship, the notice has been accepted by the government. There is no private party. But in the order, it is stated that registered steps should be taken. But there is no such response for taking registered step.
So who are
Lordship, kindly see the order dated 18th of November.
Last
Last paragraph. Lordship.
So according to you, all are represented by
Yeah,
the
government law. And already extra copy is also served. I have the Talabana. Let's kindly see the order dated 18/11, last paragraph. There is mentioned that registered steps also be taken. But my limited
Heard
understanding.
Mr. So and so learned counsel for the petitioner. Although by order dated 18/11/2024, steps to be taken. Steps to be taken by registered post. The respondents being represented, all the respondents are being represented by the
Government.
council.
Education Department, elementary.
You separate the steps or notice is to be. So, Mr. India, notice in respect of all the respondents.
Deemed
A service of notice in respect of all the respondents. A complete list and matter for admission. No. This is
No,
motion.
for admission. You will come for admission.
Yes, admission after 4 weeks.
Diploma. In the meantime, state respondent may visit the order, let's say, to produce the record. So let them produce it, that may be
There
mentioned.
is already
Apply, Lord.
Pleasure.
Yes.
The parties will be required, my lord, which they are seeking to improve.
Which one?
Water user committee.
Present water user committee.
Present water user committee.
As a respondent member,
Performer resolution number 6, Your Lordship. I have already stated in para number 2.
heard MS so and so. No objection.
No objection.
Learned counsel for the applicant and also heard Mr. I. Borthakur, learned standing counsel for PHE department, PHE department. Full stop. Next para. This is an application seeking implement of the secretary as performer respond number 6. List of having considered the grounds set forth for implement, and also considering that the and also consider that and then also consider that the land council for the and having not been objected to by the land standing council for PH come up. I deem it appropriate to allow this application by allowing the implement of the secretary. What is this?
My lord, it's a water user committee of this.
Sorry, not secretary. Users committee, page 5, huh? The users committee of retail boil pipe water supply scheme under public health engineering department, represented by its secretary. So and so, huh? As responding number.
Performer resolution number 6.
Performer respond number 6 being a necessary parties for proper adjudication of the issue in both of the connected with relationship. Instance, the integral of this instance allowed and disposed of. Next one. The in mid petition, the learned counsel for the in view of the order passing so and so, huh? Learned counsel for the provincial to file amended post title. Thereafter, on receipt of the amended post title, is registry to incorporate the newly completed performer respondent 6 in the CIS. Please. Incorporate, huh? Notice, issue notice to the newly completed sanction. Petitioners to take steps, or are you?
Steps will have to be taken.
Your Lordship.
By residence post so
Dusty service.
as well as by dusty more within a period of 3 months, 4 days, 4 days from today. This after 4 weeks.
Well, you have file affidavit, but our affidavit is there. According to our affidavit, my lord, the government permission is time logo.
For the timing, he is only code number
Who
6. Come on. No, but heavy to do.
Where's your state?
My lord,
Taken in reply.
affidavit filed by my lord, as per number 45. 21/3/2025.
What is your stance, sir?
My still lordship kindly see paragraph 3, my lord. The that as per decision of the board in its meeting held on 30th January 2024, the board developed mechanism to refrain the non-permitted institution toward the state of Assam from logging into Dorpon admission portal from academic session 24 to 25. Accordingly, the board deactivated the institution profiles of all non-permitted institutions of the state which do not have required prior permission from the Office of the Director of Secondary Education, Assam.
This is by the council.
Yes, Council.
No, council, though, you have taken a decision, the issue is,
The government should
they
take
said,
it.
once the government gives a permission,
Yes.
Yes.
So the
they have
authority-
no issue.
No.
Yes.
It is
Each
the government, what
go-
is the stand of the government?
Each government give a permission, my lord, then we have nothing to do.
That's why I have understood. That's why government cannot give permission.
I don't know, my lord, the government part,
Yes.
they will
Who
say.
is the government?
In fact, Lordship, the government while issuing the letter. What is it? Well, the issue is very simple. Our schools has been established in the year 1995. So since 1995 till the issuance of this impugn order of April 2024, the schools have been allowed to get admission of the students for the classes 11 and 12. That process is continuing. Now, in the meantime, the also individually applied before the council, and we have submitted the fees. They have not denied. Now they are saying that by filing this affidavit, if the government granted permission, then we have nothing to say. Now our grievance is that since the matter is pending before the government, so let the government take a decision, because government at one time was asking for feasibility report, and council also submitted feasibility report after having physical verification by the inspector of school long time back in 2015 and 16. There is a report, Lordship. So since everything is before the now government, so government should take a decision. Now the HLC exam is over. Now again this same issue will arise, Lordship, here. Last time because of
Which
the
period which you are
for the
agreed.
coming session 2025-26. Lordship, after
No, 24, 25 is over.
It is
No,
related to
24,
24-25.
Lordship, because of the interim order, we have been allowed to get admission for the session 2024-25.
Okay.
Now recently the HLC examination is over. Now again the admission will come up, but since because of this decision of the government,
Admission is when is likely to start.
it will be in the month of April, Lordship, after declaration of the result. April or May. So session will start from April or May.
Where in April?
Now April is going on. Lordship.
Yeah.
Yeah. Our the only obstruction is that.
Where is that impugn order?
Yes.
Your challenge, basic challenge. Yes, government, be ready.
Government content.
Why the permission cannot be granted?
Lordship, page 167.
167.
Yes. In fact, Lordship, the council also stated by this, I'm coming
It is hereby
page
notified that
167, annexure 24.
this is the impugn.
Yes, this is because of this
Category of
notification.
non-permitted
Mayor
residents
in
will
Lord-
not be allowed to conduct admission into this is first year in the ensuing academic. This is over now, 24, 25.
Yes, now
By
the
virtue of
same
interim order, you have
problem,
been- yes.
same problem will be again pop up for this session also. Because government is yet to take decision. That is why we are, Lordship, respectfully submitting that let the authority take a decision before the result is
However,
declared,
in the
Lordship.
case of non-permitted provinces which have applied for the permission with
Yes.
relevant records in the office of change, the records of those institutions will be verified and may be allowed to conduct admission.
The last paragraph is important.
If the relevant records are found in order.
Yes. Now, this exercise is also not, Lordship, completed by the council.
Council.
Now, council now, Lordship, puts back the ball to the government. Now, government take the decision, then we, Lordship, give the permission, Lordship.
Before we hear the government. Yes,
Lordship.
Mr. Chutia. Page 167, last
The last
para.
paragraph.
167.
In
Earlier paragraphs out.
Yes. However, in last
24, by elapse of time 24, 25.
Yeah,
Right.
it's-
However, in case of non-permitted private institutions, who have applied for the permission with relevant records in the office of so and so, the records of this institution will be verified.
our notification, my lord.
Yes.
However, in case
Pursuant to decision of the council, it is hereby notified that institution which is under category, which is fall under category of non-permitted private
No,
institution.
no, this is over now.
Yes.
This by virtue of interim order 24, 25 is over.
We have
Eh,
allowed, by virtue of interim order,
it's
we
gone, huh?
allowed.
Now, read the last para.
however,
However, in case of non-permitted private institution which have applied for the permission with relevant records in the office of the Seva Council, the records of those institutions will be verified and may be allowed to conduct admission
yeah,
if the relevant records are found in order.
this section.
Why not those who have got permission and applied, their document will be verified. And they will be
Verify
allowed.
and you decide.
They will decide because now document decide first of all, my lord, they will have to obtain the permission from the government. And after getting the government, they will apply it with documents. We will verify. If it is okay, my lord, we will allow. That is the step.
Who has to verify?
It is the
For-
council. It is,
No,
it is their
council will
state.
verify their
No, no,
documents.
For granting permission for the government.
Lordship, there are two things, Lordship.
Hmm.
Our school is, Lordship, upgraded. If it is a provincialized high school, it is from class 6 to class 10. The government, if provincialize those schools, in respect of those schools, if the schools are upgraded to class 11 and 12, that is higher secondary section, it is the government who will give the permission, Lordship. That is one step. Now, if the schools are non-government institution, Lordship, then it is the council, Lordship, they will verify the record and thereafter they will grant the permission.
Yours is?
Our school is also provincialized school. Also provincialized school is
Yeah.
upgraded to
Existing-
the. No, let me go. Provincialized schools have been upgraded to the class 11 and 12, that is higher secondary section.
Yes.
Now, government says they are required a feasibility report. Now, when the feasibility report given, after the schools have been inspected by the officers of the council. The council, they have inspected the school also and given the feasibility report. Now, based on the feasibility report, the government is supposed to take the decision also. Now, that decision is pending since 2021.
Hmm.
Now, in the meantime, also it is in 2024, this notification is.
So you are agreed by this?
Yes, however, there is a portal, namely Dorpan portal. In this said Dorpan portal, the institute have to register first. The institute have to register first in the Dorpan portal, thereafter they will get this chance to get admission of the student lordship. But because of issuance of this particular letter in the month of April 2024, we have been deprived without assigning any reason.
It's okay.
That is our case, Lord.
That's over now.
Yes, Lord, now my responsible submission is that let the government, let's say, directed to take a decision, Lordship, within a period of 10 days or 2 weeks, Lordship, and for the session 2025 and 26, or till the decision is taken, we have been allowed to, Lordship, get the admission of the student, Lordship.
Yes. Yes, you yourself has said that you're on the basis of record is verified and allowed to conduct admission.
It is found in order. Found in order means they will have to obtain the order of the government also. That is found in order.
That is a
However,
different issue, Lordship.
in case of non-permitted private institution, those who are non-permitted, they are non-permitted institution, which have applied for the permission with relevant records in the office of the council. The records of those institutions would be verified and may be allowed to conduct admission if the relevant records are found in order. Records of found in order means all documents, including permission. Because our notification, so many notifications we have issued to Malad applied. Our affidavit notice policy paragraph 6 also, Malad. Our stand also, our affidavit paragraph 6. The petitioner schools were deactivated in Dorpan admission portal as the institution did not have any NOC from the DSC, Director of Secondary Education, Assam. Prior permission for or NOC is mandatory for the Director of Secondary Education or the competent authority, followed by the academic permission from the council for conducting the admission process of higher secondary first year class by an institution. However, the Honorable Court passed an interim order on 17/7/2024, directing the school authorities to give provincial admission to the students of class 11 for session 24-25. The council has been directed to keep the portal open, so they were, as per interim order, we have given them. And we have issued so many notifications, my lord, to them, my lord. They did not pay any heed. 205 running page, my lord. The 14 June 2022, issue all principal, all institution, we applied. And then on 2nd May 2023, and again 1/4/2024, and again 6 April 2024. These guideline also given. So we have noticed all this time. It is not a case that abruptly we have stop entry in the portal. So government, if the government give a permission, then let the government decide it, then we have nothing to do. The government is permission because this is administrative permission. We are only giving the academic permission. So the administrative permission is in the hands of the Director of Secondary Education. So if the Lordship direct the director, then by virtue of this order, they can come and they can apply. And then council is bound to give them. If the government order is not there, the council cannot do it. We time and again remind them, you applied. If submit all
No, there is a earlier point of time, there is a feasibility report that it can be.
The feasibility report, it does not be the permission, feasibility report is.
On that basis, you have to decide.
Government will decide.
Who is the government?
That is the page 88, Lordship kindly see. One Lordship for a moment, page 88. 88 annexure 9. Page 88.
What 88?
3224 writ petition.
Huh?
Yes. Page 88. 30th March 2021. It is from Council to Commissioner Secretary Government of Assam. We refer to the subject cited above. I have the honor to state that feasibility report in respect of 20 numbers of Bhensa Higher Secondary School located in different districts was submitted by order dated 31/12/2015 as per government letter dated 28/8/2025. As per government letter, the feasibility report that was submitted. It is pointed out that this high school had started higher secondary section the period from 95 to 2005, but feasibility report for upgradation and provincialization of high schools and the higher secondary school was not furnished at the decision of the council, which was communicated to the government by letter dated 11/4/2006. And in the same letter, it was intimated that the provincialized high schools are under the direct control of the Director of Secondary Education, and a matter of submission of feasibility report for upgradation of such school does not fall under the purview of the council. That is, they are existing up to a class 10 is a provincialized school, and above class 11 and 12, they are fighting for 11 and 12. So above 11 to open the class first year, higher secondary and second year, that is up to the Director of Secondary Education. The Director of Secondary Education. We have nothing to do because this is a provincialized school. Already provincialized school, the director would do. However, the higher secondary school after upgradation comes under the purview of the council for academic permission and the recognition of phase number, and that too of the sanction of the post by the government. Now it is stated that this higher secondary section running in provincialized high school prior to issue of the feasibility report were managed by SMDC. The students of first year higher secondary had registered through the nearest recognized institutions, and studies higher secondary second year had appeared at the higher secondary final examination through the same recognized institution. Such practice is still continuing. They are doing. The father added that the consolidated statement of 20 numbers of Bhensa Higher Secondary School different district of Assam is enclosed, which speaks about the present status subject of enrollment percentage. And as Lordship kindly see page 94. Page 94, it is from the Additional Secretary Government of Assam to the Director of Secondary Education. This letter, Lordship kindly see, 22nd April 2021. May I read it, Malak? Inviting a reference I am directed to say that the following higher school introduced a higher secondary section during the year 95 to 2005. But Assam Higher Secondary Education Council has issued feasibility report during year 2015. The Higher Secondary Education Council has also stated that by letter dated 30th 3/2021 that the feasibility report was pending due to decision of the council not to issue feasibility report in respect of provincialized high school for introducing higher secondary classes. They are in such schools as under the direct control of the Director of Secondary Education. Because it is a direct control of the Director of Secondary Education, that's why council cannot issue any feasibility report. It is also appears that the higher secondary classes were introduced during 95 2000 to 2005 in this provincial high school, and these higher secondary schools are running since then the Bhensa school. In view of the feasibility report issued by the council, together with the prior proposal of the according permission to open first year higher secondary classes, 5-year and letter under reference, the pendency of the matter may be attended and steps should be taken to invoke the provisions of the relevant rules in force in respect of matter permission as paid for by 20 number of schools. In respect of flowing 20 number of higher secondary schools, subject to fulfillment of this letter, my lord, the government has written to the director. So director, whether director has acted upon it or not. If it is acted upon or not, then definitely permission will be given. This is a letter in between dispute to Tahlipara. There is secretary to director. It is mentioned that the non-government education institution Regulation Management Act 2006 in force, that the government will not bear the financial liability so and so. So this letter bears the meaning, my lord, because they are saying the government has written to the director, where director has not given a permission. If on the basis of this letter, director has given permission, then council has nothing to do. The council will admit it. That's why we are saying our regulation says prior permission is necessary. So page 94 is an important letter because and Lordship kindly page 98. This letter, my lord, this government says the director asks on the basis of the feasibility report, 20 numbers of schools, you take step as per rules.
That's why I'm asking.
That's a government will answer.
Where is the rule?
Rules, my lord, this
Rules
so
for
many
taking
rules are there.
permission.
Education provincialization of services of teachers.
2007.
In your
School.
under section 3, your lord.
It's okay. You said until the government grants a permission
Yes,
to run the school,
yes,
right?
yes.
You cannot do anything.
That's why, my lord, they should approach the director because page 94 specifically, my lord, mentioned by the secretary and written to the director of secondary education. You do that for 20 schools. But why they are not doing, we don't know, my lord.
Section 3.
Section 3, your lord.
Which one?
Successfully provide, yeah.
108, your lordship, page 108.
Ah. Yes.
3-1, your lord. 3-1. The venture education institutions which have been established and have obtained the required permission, recognition, affiliation, conference, as the case may be, required for the concerned institution from the respective competent authority on or before 1/1/2006, your lordship. So permission for provincialization, your lordship, that has to be obtained on or before 1/1/2006. If it is after 1/1/2006, then provincialization will not be given, your lordship. And your lordship, regarding the permission, your lordship, if your lordship peruses the impugned order, your lordship.
Process subscribe the board, lordship. It is the board
Provided.
provided, yes.
Provided.
provided that the permission for.
provided that the permission for the first year HS clauses in respect of high secondary schools, conference for first year HS classes in respect of senior secondary schools, recognition from Board of Secondary Education Assam
Yes.
for so and so in respect of high school. Oh, apna chahiye. In respect of, shall be treated as the permission, conference or recognition. The permission from the board is required, your lordship.
Who is the board?
Board,
Council.
council, your lordship.
Board means council.
Council, your lordship.
Council. Concurrence for first year higher secondary classes. It's first year only.
Higher secondary first year.
First year.
In respect of senior secondary school.
Both the authorities are responsible for granting permission. Lordship. Now here, Lordship, the council, Lordship, they have, Lordship, shifted the burden to the government and government shifted the burden to the council, Lordship.
Concurrence
So
in
my
respect of-
respectful suggestion is that, Lordship, both the authorities may be directed to take steps, Lordship, and they will, Lordship, communicate what will the requirement of the documents, Lordship, regarding the feasibility report. And thereafter, let the authority take a decision, Lordship, within the period of 2 weeks or 10 days. Because after declaration of the HLC
Eligibility
result,
criteria for selection of education institute for permission and service of teachers, tutors. This, is it required? Is it not?
so
for-
here, Lordship, there is a difference, Lordship. This act is exclusively for those institutions who is sought to be provincialized.
Permission.
But here it is a case, Lordship, we are not asking for provincialization. We are asking
You have
for
made a prayer
Prayer.
some prayer.
Prayer is made, your lordship. The last.
provincialization, whether we are.
We are not pressing this prayer.
No, please, Lordship, I'm sorry, Lordship.
No,
No, we are-
provincialization.
whether we are entitled for provincialization or that,
No, we're not considering at this stage.
Lordship.
We're not considering. Though you have made a prayer.
No, Lordship, may
Isn't
consider,
it?
but the first priority, Lordship, are the regarding the, Lordship, permission to accommodate the students of first, higher secondary first year and second year.
That is where we're
Yes.
on.
The-
Whatever. The rest will be as per the.
Yeah,
Act
2017
only.
Rest to
So
other-
we're not concerned. We're not determining whether your services should be provincialized or not. We're not.
No.
No, you have made a prayer. But all the submissions are with regard to permission only.
Once the school get permission or recognition, thereafter schools can apply. Now, prior to having the permission or recognition, let's say there is no question of applying for provincialization.
That's what I'm saying.
Yes, that is why
So
my,
we cannot say now,
yes,
we cannot determine whether this should be
Yes.
the teachers.
we are
and the
entitled
staff
for
can be
provincialization or not.
provincialized So
Yes.
we're not
That
considering.
is to be kept open also. Now, so far the permission or the impugn order
I
letter.
think he's fair enough. You consider.
So our
What of you?
also kindly say, have a look, my lord.
No, regulation will not override.
Regulation.
It's a regulation.
Regulation will not override. This
No,
2004.
regulation is a statute regulation, my lord, under Act 1984.
Huh?
Yes. The revised regulation on the recognition of higher secondary councils. It is under Act of the 1984.
Which is this?
Page 2, lordship, kindly see. Page 2. Clause 1. Application for permission to start a higher secondary school junior class. Skip it, my lordship. The
Page
page
3.
3. Sponsored body shall be submitted application to the secretary.
Which one?
Such application shall be made in the.
Assam Higher Secondary Education Council. Revised regulation, so this. So, where is this? This has been framed under what?
Page 2.
Ah,
Page 2, yes. Paragraph, clause 1. Application for permission to start higher secondary school.
Hey.
Have you also got it?
yours is for upgradation.
Upgradation, yeah, that's why,
They're already established.
that's
Yeah.
why
Sir, I'm asking which, under which law this regulation has been framed?
yes, lordship, can you see page 3 down? Page 3, paragraph 1, 2, 3.
Ah.
In case of existing government and provincial high school.
I understand the requirement, which law you have framed this regulation?
1984.
Where does it
Education Act.
say?
Yes, secondary education in 1984.
Where does it say?
Lordship, in the definition part. Act means.
Yes. Higher secondary.
Assam Higher
education.
Secondary Education.
No, I am asking this regulation is framed under which,
Assam Higher Secondary Education Act 1984. This is statutory act, and
Yes.
under this act, this
what is the relevant provision
this Lordship can
to,
definition.
they authorize you to frame
Yes, definition Lordship can see.
No, no. under which
Yes,
section?
yes, 84, there is the provision, yes, regulation. 84. Oh, 84, yes, 511.
Assam Higher Secondary Education, 1984.
511.
Oh, yes, ma'am. Okay.
No. Assam Higher Secondary.
Yes. Assam Secondary Education Act 1984, on page 511. This book, my book, this one.
Yes.
Lots of
Which
kindly
provision?
there is a provision,
For making regulation.
definition, and 24 I think, Manoj. Termination, disqualification, resignation member between councils. Council pending the powers, duties of a council. Power of government, the power, duties of chairman, power of the secretary, application for account of council. 24, my lord. Section 24, power of council to make regulation. Page 522. It is education code, my lord. Power of council to make regulation. Clause 1, subsection 1, the council may, subject to the approval of the government, make regulation for the purpose of carrying out the provision of this act. So, in particular, without prejudice to the generality of the foregoing power, the council may make regulation providing for all or any of the following matters, namely, all these are things, my lord. So, this regulation has been made under this provision, section 24 of the Assam Higher
24
Secondary
of which
Education Act
clause?
1984.
Which clause?
Not defined, Lordship.
Condition of recognition of higher secondary schools
Yes.
shall be admitted to the examination of the discipline measures. Appears to be clause F. So are you trying to say that regulation will override the Act of 2017?
Not overrating, Mala. Under this act, this regulation is made.
Yes.
That's why this is the statutory provision, statutory rules.
So,
This Act Secondary Education Act 1984 has given power under section 24 to make regulations.
so now, is there any conflict
No conflict.
under
Mala.
this
No
regulation in
conflict.
2017?
No, Mala. As
So
per this,
2017 requires a concurrence of the board.
yes. Board has
So you
concurrent.
just cannot, the hands off.
No, this
You
power.
just cannot, pass the buck to the government. Equally, you are responsible. Concurrence of the board is required. So both the state government and the council act as per the council, as per the rules and the act, regulation and the act.
As per rules and regulations, they will consider. They are submitting the, DECA is submitting right way, my lord. Lordship sent it to the government, the
Yes.
government will decide it.
Within 15 days, you
Yes,
decide.
Lordship can give it time.
So prior to, specifically, Lordship make an observation prior to declaration of the HLC 10th result. Lordship.
When it is likely.
Because once the result is
When
declared,
it is likely to.
Lordship in by the,
I cannot
the
say.
best authority.
No, my lord,
when it can be
April,
declared.
May first week or June
So
first
today is
week.
10, Lordship. Within 10 days or 2 weeks, Lordship.
No, within 10 days, it is not possible for the government.
No, already feasibility would every entire
Or
record.
within 10 days, my lord,
We'll make it,
I don't think.
we'll make it 3 weeks.
3 weeks, my lord.
3 weeks, all right. We'll not go into the right and all those
Yes,
things.
yes,
We'll
yes.
record the submission.
No,
review submission, and
we-
then we'll say that.
No, we
in
have
view of the- As per
sympathy.
the provision, both the state respondents as well as the council.
Also, it is not a matter of sympathy. Since 1995 till 2024, for long 29 years, the schools have been running.
We're not
Students are
commenting
get
on
assisted.
your entitlement or not. That
Yeah,
is
the
already on the
government will
record,
decide
they'll
it, but-
consider, because you have submitted all the required documents.
Yes, yes,
also.
we have deposited fees also.
Ah. So everything according to you have
Support for the
submitted
board
all
the
the
authority.
required documents
The
along with
government,
the feasibility report.
Yes, that's already submitted.
the government will decide it, Malord.
Both, not
And
only
both,
government.
if
Because
something is
concurrence
required, they must assist the government also.
You have already written to the government. But
Yes,
then
page-
you have,
page- page
you
88
have the
Lordship.
authority to give concurrence.
Page 88.
Now,
Lordship.
whether they have submitted to the council or I don't know, Malord. I don't have the idea.
Oh.
They have
Wait,
said
wait,
to the submitted to the government, that is true. We have seen it. But to the council, whether they have submitted all documents or no, I don't know. If not submitted, let them.
No,
Lordship,
no,
Lordship,
you-
Annexure 3, page 76.
Ah,
This is the Lordship receipt, whereby we have deposited the
council.
fees for
Yes,
permission
already.
before the Lordship Treasury Office.
হ'ব দিয়া, হ'ব দিয়া।
Yes, heard Mr.
হ'ব দিয়া, মই আমাৰ এখন-
Ken Chaudhary. Senior Counsel Assistant by MS K Devi. And
Yeah, Decca Lord.
and K Deka.
Decca.
Deka, Learned Council. For petitioners, how many?
Here in the first case, Lordship, there are 27 numbers of schools.
Hmm.
There are other repetition also.
Other repetition also, I'll give you better on my left.
Huh?
I'll give you number.
Name, this petition and the name of the lawyer.
Yes.
Ah, and also her,
I am for 4 and 5.
we'll just record her name.
120.
Huh? D. Musahari, Standing Council, Higher Education, Secondary Education, Standing Council, Secondary Education, respondent 1, 2, and 3. And Mr.
4 and 5.
And RK, DK Roy.
I being a standing council, Malord. He is assisting me, Malord. Not as a additional senior government advocate, being a standing council.
So and so, for
Council.
respondent number 5. Assam Higher Education, what is this?
Now, Assam State School Education Board.
Assam State School Education
Board. Now,
Board.
as 12 manner, it was Assam
Council.
High Secondary Education Council.
Council. Now it is.
Now it is SF,
You just say,
Assam State School Education Board,
Assam.
at present. Obliged, Malord.
I'll pass the order.
15, 19, 20, 21.
Lordship, may kindly take note of Annexure 6 and 8, Lordship. Annexure 6 is the government request to the Director, Lordship, for granting permission. That was in page, Lordship, 65.
65.
Or Lordship, may go to, there are 2 affidavits, we have filed reply. One affidavit, reply is to the
No,
government.
just annexure, next
Yes,
annexure.
Annexure 6, Lordship.
Yes, page 65.
6,
No,
sorry, 85.
85.
85, 86, Annexure 7. These are the government request to the director to take
Yeah,
steps, Lordship.
he has read out already.
Page 85. This is, Lordship, from the government to the director, petition for government permission in respect of 20 numbers of Hampshire higher secondary schools. In enclosing herewith copy of letter number so and so.
Page 85 to 87.
Yes, Lordship.
Then annexure,
Annexure,
next.
Annexure 6, Annexure 7, Annexure 8, and Annexure 9.
Nine.
These all are the communications made between the government as well as the
7, 8.
council regarding the permission for the
7,
higher.
8, 9.
Yes, regarding granting permission for higher secondary first year and second year classes. In respect of the institution law.
Malad 18, 19, 20, 21, 22, 23 are same. Same.
Same in the sense.
Same
Same set of council.
Same.
All right.
Oh, good.
Obliged, Malord.
So why not commenting on your other prayers for provincialization and all?
Not for
That issue we kept open, Lordship, because once we get the permission. Then
No,
we can
that's
apply.
always there. Once it is provincialized,
Lordship, make an observation that after they are getting the
Yes,
permission, they can apply. Lord.
no, that is always there. You can do it.
It is the second stage, Malord. The
Because,
first stage is to have permission.
yes, obviously, once it is provincialized, permission means
To start classes.
That
to
That
get
will be
it.
different thing.
This state, they are fighting for
That
this
is
state.
distinct from provincialization.
Yes, Lord. Permission, these are the
Where on
criteria.
permission only?
This is the eligibility criteria to
Criteria.
provincialize the school.
Yes.
The first
So once
requirement is
per-
the permission
Once
and
permission is granted, you may seek for.
They
permission.
may apply for provincialization.
So we're concerned about the permission only.
Yes.
By this writ petition.
Permission, yes.
Although you have prayed so many things.
Lord,
Yes, yes.
So we're just.
Permission, yes.
Will confine to
Permission.
permission.
that impugn letter of April 2024. Deeply obliged.
Obliged.
42 আছে না লগতে?
This also.
May it please your lordship.
Yes.
Lordship, hearing the case, the secretary to the Government of Assam Finance Department has been arrayed as party respondent number 2. But he is not necessary in the proceeding or he has no role to play. Therefore, my prayer is to scrap off his name and fix the matter after verification for admission.
You file an application. You have made them party.
Yes, Lord.
You file an application.
Because in fact, the respondent number 3, I find from the record is United Bank of India, my lord, that no longer exists. Since 1/4/2020, that has amalgamated with the Punjab National Bank. Is now 5 years. I am only for, in the present case, I am only for 4 and 5. This is the Assam Gramin Vikas Bank. This is a disciplinary proceeding, even otherwise the state perhaps would not be a necessary party. It's only a pro forma party.
Then,
So
2 and 3, both maybe as my learned friend has submitted. That may be scrap off and the matter may be fixed after verification. Alright.
Union of India, Secretary of Ministry, is there. Union of India is
Union
there.
of India, my lord, I believe it's only a pro forma party because this is a disciplinary proceeding case. My lord. Union would
The state of Assam by Secretary to Government is not,
Yes.
not correct.
Not necessary.
not correct. And
And-
3, my lord, does not exist.
3 doesn't exist.
No.
Then
4 and 5,
discipline proceedings.
disciplinary proceeding. I am for 4 and 5.
4 and 5.
Yes,
Discipline concerned authority is you.
yes, 4 and 5. This is the concerned bank.
Okay. Heard Mr. So-and-so, learned counsel for the petitioner, and Mr. So-and-so, learned counsel, standing counsel,
Yes, I am for
Learn-
4 and 5.
standing counsel.
Yes, standing counsel
Learned
for 4
standing
and 5.
counsel for respondent 4 and 5. Next paragraph. It is submitted by learned counsel for the parties that the respondent number 2 is not a necessary party in the state proceedings. And the respondent number 3. Respondent number 2, the secretary to the Government of Assam Finance Department, right, is not a necessary party in this state proceedings, right? And also the respondent number 3, United Bank of India. What is this? No longer?
No, my lord, it has amalgamated with the Punjab National Bank.
Has amalgamated with the Punjab National Bank,
Yes, on 1/4/2020. my lord.
1/4/2020. Therefore, both the respondents we may be start off, huh? Listen. So do you need to make party to them? No. To the bank? No.
No, only 4 and 5.
4 and
In my
5
humble
is
submission, only 4 and 5 are the necessary parties. Others are not.
Okay. Next paragraph. In view of the submissions of the land parcel for the petition, parties, the name of the respondent, number 2 and 3 are the 3 stances struck off, in the struck off from the array of parties. List them as agreed to by land council for the parties. List this matter after 4 weeks. Right, let's see.
Please, your lordship. This petitioner, my lord, were working, my lord, as one of them was working as a boatman, others were sweepers, my lord. Now, my lord, they are seeking, my lord, the scale, my lord, minimum scale in terms of judgment of Upendas, my lord. Now, their case was that, my lord, they were working, my lord, and my lord, they were given only rupees 2,000 rupees per month. That too was not being paid in, my lord, regularly, and my lord, there are areas of that, my lord, payment we made, in fact, which has been admitted by the state. My lord. Now, my lord, so far as, my lord, this, my lord, payments are concerned, my lord, they have taken a stand that we are, my lord, part-time appointees. My lord, whereas our case is that, my lord, that we are, my lord, discharging our duties full-time, my lord. On the basis of, my lord, whenever we are allowed to ask to work, we are discharging our duties, my lord. And, my lord, suddenly the last affidavit, they have taken a stand, my lord, that we have been terminated. No, not terminated, but we have been discontinued, my lord. Now we have filed a reply to that, my lord. There is no order of discontinuation, my lord, nothing of the sort, my lord. And whenever we go, my lord, we are allowed to, my lord, work, my lord. But then that's how it's been continuing, my lord. In fact, they've admitted that we were working for till some point of time, but they say that we have been, my lord, discontinued, my lord.
When?
My lord, they say, my lord, one of them was discontinued, my lord, in the month of, my lord,
February.
April 2023, if I'm not wrong, my lord, and
February
others in
23.
September, my lord.
October.
Similar in view of that, my lord, we have filed a
Petitioner
reply. My lord.
number 2 and 3 have worked up to February 2020.
Yes, my lord.
And petitioner number 1 up to October 2023. Yes.
So this is what they, my lord, we have filed a reply to that, my lord.
So what do we try to say?
My lord, we have said, my lord, that we are working, my lord. Whenever we are allowed asked to work, my lord, we discharge our duties, my lord. Now the case is, my lord, since the matter was pending before this, your lordship, my lord. They have, my lord, in some cases, my lord, the affidavit before that, my lord, we had brought on record. In some cases, my lord, this regular scale was given, my lord, to many people, my lord. So when there's a scheme, my lord, when there's a, my lord, process being, my lord, initiated with regard to others, my lord, we are entitled to similar relief, my lord. They cannot, my lord, discriminate on that. And so far as this ground of, my lord, discontinuation, my lord, all this, they have filed a number of affidavits, my lord. Nowhere they've taken this stand. Suddenly they come up with this stand, my lord, that we have been discontinued, my lord, in the last affidavit. Otherwise, what they are trying to contend is that, my lord, that we are, my lord, part-timers, my lord, and therefore, my lord, we are not entitled to similar payments, my lord. That's what they're trying to contend, my lord. As against that, my lord, we brought, of course, this is, of course, a little different, my lord, because this is with regard to the, my lord, Factories Act, my lord, where there's a minimum wage, my lord, being prescribed for, my lord, people, my lord, who work in factory, my lord. Our case, my lord, state being a model employer, my lord, you are asking, my lord, other people, my lord.
How you were appointed?
My lord, our appointments, my lord, lordship will find the appointment of letters are there, my lord. These are all, my lord, casually, my lord, employed in, my lord, page 15, my lord.
No, problem is now how you will, I mean, compensate all those things?
Pardon, my lord?
When they say that your service has been discontinued.
My lord.
By 2023.
My lord. That is, that, my lord, they are just, my lord, they are not given an order, my lord, discontinue our services, my lord. We were appointed in pursuant to some orders, my lord. Suddenly they say we have been discontinued. We cannot be done verbally, my lord, first of all. Secondly, my lord, when the matter was pending before lordship, my lord.
You are not challenging that.
My lord, they have not given us any order, my lord. They have not passed any order against us, my lord. What we challenge, my lord?
Brought on affidavit.
We have, my lord, we have replied, my lord. Then we said, they are working, my lord. Unless they will pass some order, my lord, what we challenge,
How
my
do
lord?
we know? You are working. They are the employer who has employed you, and they are saying that your service has been discontinued. You just cannot that I should be allowed to continue like that.
Therefore, my lord, they have to show some orders which they have passed, my lord, discontinuing us from service. They have not passed any orders, my lord. Verbally, my lord,
That
saying.
doesn't give a right to continue. Once they said that you have service has been discontinued.
That will be dangerous, my lord, because anyone can say anything, my lord.
No, on that we cannot presume that you are continuing. Once they on affidavit they say.
My lord.
How do we say?
But in that case, my first submission will be till the period which they have admitted we are working. At least till that period, their wages should be paid, my lord. Say no similar basis, my lord. And secondly, my lord, when the matter is pending, how could it that my lord?
Lordship, the last affidavit we have filed as per the direction of this honorable court, not suddenly filed, your lordship. And court specifically asked that whether they are working or not. We have specifically said that they are not working till 2023. And they are, one of them is verbally appointed, your lordship. Then why should not they discontinued verbally, your lordship? And all of
Others,
them.
what about the others?
Others are part-time workers. We have clearly stated in their appointment letter that we have filed
Part-time
affidavit.
workers. yeah.
Part-time workers, and they are not full-time workers. They are not continuing lordship from
Why don't you pass an
2023.
order? Why you should say verbally?
Lordship, why, and regarding salary, your lordship, we have admitted that there are some amount is due against them, and we have admitted that we are going to pay within a short period of time. Your lordship, except that salary, they are not entitled for anything as per our submission, your lordship.
That is of 2,000 rupees, my lord, that also they are not paying, my lord. That admission is withdrawn, will
They are
come
ready
2,000
to,
rupees.
ready to.
That I have admitted.
And so far the others are concerned, my lord, if, my lord, I've got two aspects to that. First of all, my lord, the period till I'm working, they admit we have worked, my lord. Till that period, they have not, my lord, they are not paying the minimum wages, number one. Secondly, my lord, when the matter is pending with your lordship, my lord, how could they have, my lord, terminated, my lord, that this, my lord, this is to, my lord, circumvent the, my lord, the proceedings before this honorable court, my lord. Without any orders, my lord, now they are, my lord, my learned friend is saying one of them was verbally appointed. We have given all the appointment letters, my lord. It's totally incorrect, my lord, to say that we are verbally appointed, my lord. None of them was verbally appointed. Now, my lord, discontinuation, my lord. Simply, my lord, they are saying they have not passed any orders, my lord. They have not passed any orders for discontinue service.
Minimum
Can it be done, my lord?
lordship, they are not entitled because give the minimum whether they have to continue from 10 years continuous service is required.
Yes.
As per the open does, your lordship.
Yes, my lord. More than that.
But they are temporary workers, your lordship, part-time workers, boatman sweeper. How they could be a full-time worker, your lordship? Their appointment letter, it is clearly written, your lordship.
Where is the appointment order?
My lord, page 15, my lord, number one, my lord. Nomenclatures will not matter, my lord. It is, my lord, the nature of duty they are performing, my lord, first of all. And my lord, I'll show, my lord, how, my lord, it is to be treated, my lord, if they're part-time, my lord. There are, my lord, certain principles, my lord. Of course, my lord, this is under the fact, my lord, minimum wages act, but there are some principles are there, my lord. Lord, where is the part, my lord, for example, my lord, petition number 1, my lord, where it is stated, my lord, he was appointed, my lord, on a, my lord, part-time basis, my lord.
Yes, your
Subsequently,
lordship.
in some orders, they, my lord, put it, my lord, but initial order, lordship will see, my lord. He has been transferred also, my lord. Page 15, my lord, there is the first appointment order, my lord. There is no mention of part-time, my lord. Then lordship will see
But in
his.
extension order, it is mentioned, your lordship.
My lord, they're trying to circle, my lord, page, my lord, annexure 5, my lord. This person was even transferred from one place to another, my lord.
How you were appointed?
Yeah, these are all, my lord, these appointments, my lord, definitely, my lord, these are not, my lord, regular appointments, my lord, because of they are, my lord, mostly, my lord, master role or fixed pay, my lord. In that manner, they are appointed, my lord.
It is stated that they are purely temporary basis and may be terminated at any time without assigning any reason thereof.
Well, that is the reason why Upendas came in, my lord, because these are the people who have been exploited, my lord, engaged, my lord.
And in
Since
extension order,
1990, my lord.
it is stated part-time boatman, your lordship. And we have filed one affidavit where we have annexed the appointment letters, your lordship.
Heard, Mr. I'm the learned counsel for the petitions. Attempt 26. And also had MS
Ardeka,
Ardeka.
Oh, water
the
resource.
Council for Water Resource
yes, your lord.
Development Department,
Water resource department, your lord.
Water Resource Department. Admit the writ petition, list for hearing after 3 weeks. We'll look into all those open and all,
My lord, lordship fix a date.
because we just cannot,
Lordship can fix a date.
no, after 3 weeks, we'll do it.
Okay.
List for hearing, huh?
My lord.
But you obtain instruction, how just can verbally discontinue?
Yes, your lordship. I will obtain.
It cannot be done. Wrongly or rightly, temporary, whatever you have appointed them, just simply mentioning temporary will, will not give you a right to, fire them without any procedure. The minimum procedure has to be there, at least you have to issue some, take some decision, pass some order.
Then
Just
we go to
because
the
matter is,
chairman.
I will
just
obtain.
because matter is, taken to the court, doesn't mean that you will just say that on your own whims,
Yes.
say that they are fired and they are discontinued. You cannot do that. Otherwise, we'll have to explain, he has to explain. Concerned authority has to explain.
May I please, Your Lordship?
Yes.
My lord, is 19 petitioners, my lord, out of them, my lord, 3 are for teachers and others are for tutors, my lord. They are claiming, my lord, regularization of their service, my lord. And they are similarly situated candidates, they have already been regularized, my lord, by order dated 4 to 2021, my lord, Annex 9, my lord.
Hmm.
So, my lord, this matter is pending for since 2022, my lord. They are not filing any affidavit in this matter, my lord.
Where is this regulation?
My lord, page 200. Annex
200.
9 PDF, my lord.
200.
200, my lord.
Why? Voluminous.
My lord, so many documents are there, my lord. It's why it is voluminous, my lord. Page 200, my lord, Annex 9 series, my lord.
How you are similarly situated?
My lord, petitioners are from different senior secondary schools. And my lord, these impugn orders are also in series, my lord.
Hmm.
So page 200, my lord, may I read, my lord?
It's okay. Comment on in the second, probably
Make
continuous
section
session, so and so mentioned. Please to provide service of the teachers is non-teaching students. Supervisor Janta Senior
Yes, my
Secondary
lord.
School. Same school
Not all are not same, my lord. This is for petition number 1 and 2, my lord.
with effect from 1st of January. Huh?
This first copy is, my lord, for petition number 1 and 2. Then, my lord, other schools are also there, my lord.
Why your case has not been considered?
My lord, they are not citing any reason, my lord.
So
Lordship, we have
file an
received the,
affidavit
yes, Lordship, I have received my
within
instructions.
2 weeks.
My
Not
lord,
Mr. So-and-so, learned counsel for the petitioners.
date may be given, my lord.
Mr. MS
H. Terangpi, Lordship.
H.
Terangpi.
Terangpi, learned counsel for the learned standing counsel.
Yes, Your Lordship, for secondary education.
Secondary education submits that she has received the instruction. List of therefore president sometime be granted, sometime may be granted to for filing affidavit.
Without filing or dispose to by law.
Considering that the matter is pending since 2022 for
How about it?
filing for and no affidavit has been filed. Therefore, where the London Standing Council is granted, listed matter after 2 weeks in the meantime. London Standing Council for Education Department, what?
Secondary department.
Secondary Education Department to file affidavit. What is the instruction? They are not similarly situated.
Yes, Your Lordship, the service of Nazrul Haq and others could not be provincialized as the school received government concurrence in their respective subjects after 1/1/2006, Your Lordship.
No, my lord, that is not.
No.
Yes, ma'am.
You will be given a
Yes, sir.
chance to.
My lord, may I
Because after 1162, you cannot.
Yes,
So,
Your
but in case
Lordship.
it is correct.
my lord, may I pray for a date, my lord?
After 2 weeks, let them file.
Okay.
Lordships, in this matter, may I pray for 2 weeks further time, Lordship? The department has asked for extension of 2 weeks time, Lordship.
For what?
Immediately after for furnishing instruction and filing affidavit, Lordship.
What, Mr.?
The Hukum.
Boro, my lord.
Hey, Boro.
Yes, sir.
Learn concept of this. On the prayer of
The Hukum,
you learn standing council,
Health and Family Welfare.
health and family welfare,
I am appealing on behalf of Accountant General.
and Mr. Boro. Granted for the 3 weeks time to file affidavit.
Highly obliged, Lordship.
My lord, this may be last time, my lord, because they
What
have
is
taken
this?
so many things, my lord. This case.
May I be please, my lord? Waiting for the instruction, my lord.
Who?
The petitioner is waiting for we are waiting for the instructions.
What instruction?
Petitioner is out of city.
Huh?
Petitioner is out of station, my lord.
Who?
Upper petitioner. Valid.
MS so learned counsel for the petitioner submits the he is yet to receive instruction from the petitioner as granted by this court on 21/03/2020. Mr. Therefore, first of adjournment of the matter for further 3 weeks. Gradually, this after 3 weeks.
I appear for respondent number 7 and 8, accountant.
I'm for government lordship.
Are present.
Eight and
Are present.
We need some time to file affidavit.
Are Mr. So learned counsel.
And these are,
Mr.
these are Borough Lordship, respondent number 4 to 14 and 16 to 21. Private respondent.
The price for him is granted 3 weeks time to file affidavit. You also.
Yes, Standing Council, Apex Bank is. Standing Council, Apex Bank. SC Apex Bank. Respondent,
1 to 3. No, I think 33. Mr. Yuchel here told me that they are going to file it.
Lordship, we will be filing our affidavit in the course of the day.
Or Mr. Embro. Boro. Eboro learned counsel. It is submitted by MS
Ideas on behalf of the Upamendment.
Ida so and so. Appearing on behalf of Mr. D. Upamani.
Yes,
And
Your Lordship.
standing counsel
For the education department,
Yes,
medical,
yes.
sorry, health department.
for health department submits. Will be filing the affidavit during the course of the day. Will be about this matter after 2 weeks.
For 2 weeks.
Yes.
Okay.
Lordship, in this matter, Lordship, I sought instruction, Lordship, instruction received, Lordship, affidavit ready, Lordship.
What is
I
the
have
matter?
to file, Lordship.
Lordship, respondent number 5 has already filed their affidavit, but they have not served the copy to us. So we may
Who
be,
is for respondent number 5?
Yes, I'm.
You serve the
The
copy.
private respondent.
What Mr. MS so and so learned counsel for the
I
police.
will serve another copy. Already I have served and then you.
MS, Mr. So and so learned counsel for the respondent number 5. To serve, to furnish a copy of the affidavit of position
Lordship,
to
include
the learned
that
counsel
may
for
be
the
continued.
petitioner. And Mr. J.K. Goswami, learned counsel addition senior government advice. Is granted further 3 weeks time to file affidavit. Interim order.
Lordship.
First, let's continue. Yes, next.
May I please have a question? That matter relates to the provincialization of service. Well, that petitioner service was first provincialized.
Provincial.
Provincialized.
So,
So
what is
thereafter,
the
my lord,
problem?
my lord, problem is that when the salary of the petitioner was not paid, my
Yes.
lord,
So,
so thereby the petitioner file a writ petition before this honorable court. My lord.
yes,
During pendency of this writ petition, department has filed affidavit, my lord, indicating that then my provincialization was cancelled, my lord, because of reason DSC was not recommended earlier. Without recommending our case, provincialization are done. So, my lord, I am chronologically, my lord, I have challenged that rejection order, my lord. I take ownership.
cancellation order.
Cancellation order
This is against the cancellation.
against the cancellation.
Yes.
My lord, I take your lordship chronologically for a moment, my lord, some of the annexures, my lord. Annexure 1 is
You
the,
show the impugn order.
my lord,
Yes, who is for
And-
the respondent? Yes, come to the impugn order.
impugn order. Annexure 10, page 37. My lord, government has, department has filed affidavit, my lord.
37.
Just quoted the entire impugn order, nothing more.
Hmm.
May I read, my
What is
finding?
this?
The
Ah.
DEO Borpeta submitted proposal with recommendation of DSC Borpeta for permission of service of Novamilan Emi Madrasa as per Act 2017 as shown below. Name of the school, name of the teacher. They were Arshad Ali Sikdar, Abdul Hamid Sikdar. Well, these are all died and one is retired. All of them, my lord. Ali Ahmed Khan. Next, on the other hand, DEO Borpeta submitted proposal for permission of service along with the school and teacher data of the following teachers through email against the such and such, such and such. The DEO Borpeta also submitted a proposal for permission service of the petitioner without recommendation of the DSC Borpeta. Rafiqul Islam, my lord, is the petitioner, my lord. Next, my lord, after receiving the proposal, this office has placed the matter before the SLSC as well as joint committee constituted by government for permission service as per Act 2017. And accordingly, both the committees recommended the following tutors against such and such. Here is also, my lord, Rafiqul Islam name. Now, thereafter, the office submitted proposal to the government for creation of tutors post against the Novamilan school and the government sanctioned post, and subsequently this office issued provincialization notification dated 4/2/2021 of the following tutors. This is Rafiqul Islam, Mala, provincialization order. I have annexed, Mala. After provincialization of service of the tutor of such and such, DO Borpeta submitted proposal for release of first wave of 8 numbers of tutors, including the tutors of Novamilan Emi Madrasa DEO Borpeta. Accordingly, for verification of the document of the above mentioned tutors, the DEO Assam conduct a hearing on 17/2/2022. Accordingly, hearing constitute submitted the report of the hearing in which stated that tutor Miachan Mia and Rafiqul Islam, whose services were provincialized against the such and such, were appointed by the SMC and they had acquired the requisite qualification and age, but they were not recommended by DSC Borpeta for provincial of their service.
You are heard.
Malak, heard. On the other hand, as per documents submitted along with the report, it is seen that DEO Borpeta has suggested name of the tutors of provincial of service without recommendation of the DSC Borpeta. Also, as per office record, DEO Borpeta had furnished the names of the tutor in the soft copy of the proposal submitted for the provincial service. Our soft copy has been sent. Only hard copy had not been sent. In the affidavit also, they stated the same. Hence, the hearing the committee concluded that 2 numbers of tutor, Miachan Mia and Rafiqul Islam, whose service was provincialized against such and such, are not entitled for provincialization of their service, were not recommended by DSC. Only reason is the DSC. Well, that is why state level hearing conducted. My lord, as per law, my lord, I am discharging social studies science, my lord. Only 3 teachers allowed. At present, 2 teachers were at present, including me, my lord, 2 teachers discharging their duties, myself, and I have stated in that. Now, question is.
Requirement is that the district scrutiny committee has to recommend.
Recommend.
If it is not recommend, matter ends there.
No, my lord, the law said, thereafter the as per section 310, my lord, state level committee own its own motion has to inquire about the matter and examine the document. That is why it was done earlier. That is why my provincialization was done.
Wrongly done. Wrongly done. It is found that your name has not been recommended.
Exactly. Now they can recommend. There is a judgment of this honorable court, my lord. Your lordship, letter I am with all documents, my lord.
So as the judgment.
My lord.
What does it say?
My lord. And your lordship judgment is also there, my lord. Other day I have your lordship in a case of my lord. Since at present it is not a dispute that the more than categories teachers were appointed, or even 2 teachers, even my lord, there is a my lord, mandate of the law, my lord, social studies have to be considered. It is not even that
It's not a question. of-
recommend,
Your
my lord, so
effort-
far the recommendation part is concerned, my lord. My lord,
Your appointment has been, provincialization has been cancelled
my lord, only
because
because
your name has not been
recommended,
taken
yes.
with the SC.
Now recommend it, law says so, my lord.
Huh?
Yes, my lord, I take your lordship, section, provincial, my lord. Later on, my lord, I will satisfy your lordship.
After 3 weeks, 2 weeks,
My lord.
heard Mr. A.K. Hussain. Otherwise, I'll dismiss your writ petition.
My lord. All right,
Appears
my
to
lord.
be something wrong. You have pledged something.
No, my lord, 2 weeks, my lord. 2 weeks, my lord.
2 weeks.
My lord.
A.K. Hussain, learned counsel for the petitioner. And Mr.
A Fukan, my lord.
A. Fukan,
Elementary education.
elementary education. Make it 3 weeks.
My lord.
As agreed to by the learned counsel for the parties. This letter after 3 weeks.
Deeply obliged.
After 6, I'll satisfy your lordship. High level.
I have, may I please your lordship. Lordship, I need a small prayer in item number 56, lordship. My senior counsel, Mr. Nolin Collier mentioned, lordship.
Sometime to obtain instruction as regard the
Earlier order dated, my lord, 17/3/25, as per earlier order, 17.
petitioner. Therefore, praise for adjournment the letter for 3 weeks. Next paragraph. Prayer not being objected to by learned counsel for the petitioner, Mr.
P.N. Sharma.
P.N. Sharma. P.N. Sharma, learned counsel from the, please this, praise the Lord, please this letter after 3 weeks.
May I pray for fixing a date, lordship? Because that urgency is there because that documents is required
Any
for admission of the
First
children.
week of May, my lord, any date, first week of May.
Date
my
will
lord.
be fixed, lordship.
His documents is with you.
That, whether documents are with the authority or not, that instruction is required, my lord. That instruction I have not received.
You have not filed the affidavit.
No, my lord,
Have
that
you filed
issue,
the affidavit?
that issue is raised only on the last occasion, my lord. They have raised this,
No,
that,
prayer is there.
my lord, regarding affidavit, we have filed, my lord. Long
So,
back time.
you have not answered to that. Whether the
Regarding
documents
that issue was raised on last occasion, there during hearing on 17/3/25, my lord, because of that. We'll return the document if the document with the authority, but that instruction is not received, my lord. That remote.
However, date will be fixed, lordship.
after 3 weeks, give the date.
Obliged.
Maybe. But for retired benefits, the petitioner was retired on 31/1/2021. Last occasion, my lord, PQ number along with the order has been sent, which the petitioner has received and treasury official has called in on 9/4/2025.
Yes, any
In the
instruction?
meantime, my lord, instruction was sought from the.
Sir, any instruction?
Yeah, I've got some instruction of the recalculation has been made
Only thing is that like, the money could not be released because it was, I mean, the budgetary approval and all received a little bit late. So like, once it is done, it will be today, in fact, Lordship, some documents were supposed to be sent. So it will be done.
So we'll close
So,
the
so
matter.
I'll seek for some time, Lordship, so that
We'll
like,
close the
after
matter.
2 weeks.
My lord, so
In
for
view of this instruction.
that instruction, I have not actually gone through, my lord. What is inside the instruction? For last 4 years, my lord.
So there were some recalculations, were carried out. No. আপনাকে আগে কোথাও কথা কিছু হবে না আর বাকি যিনি বাজেট অ্যাপ্রুভাল হলো আপনি তো কোর্ট
Recalculation is not a dispute here.
So far,
What is your prayer?
my prayer is that please, my lord. 23, man. 23.
Yes.
Some calculation was wrongly made during the service tenure. That was has to be recalculated.
2014, as per 2014, they have recalculated.
My lord. And so far, the instruction, whatever is maybe in the, my lord, that particular document, my lord. Although I have not gone through it, if covers my relief, my lord, then, my lord, direction will be
In that
issued
case,
in the
you file an
meantime.
affidavit.
Lordship,
File an affidavit.
already we have filed an affidavit. Only thing is that Lordship, recalculation has to be done. Recalculation has already been done. The last line says that like once the budget, as soon as the receipt of the budget, it
You
will be
should,
sent.
according was recalculated on the basis of correct pay, basic pay with effect from March 2020, very fixed at so and so.
So, in the first paragraph.
Just show him. Last para, no, first page, last para, first page.
GPA for the
Will be sent.
That's why recalculation recalculation amount, amount to budget to 24 তারিখে বন্ধ করলে তো মারছে এটা খাতে খুলি দেওয়ার কথা হয়েছে খুলি দিলে টাকা দিয়ে দিই So Lordship may keep it
Pending.
after the BU vacation, Lordship, then we'll get the proper instructions whether it is been paid or not. Then I'll intimate you, Lordship.
That will be, and meanwhile, my lord, one copy may be, my lord,
That I'll give.
Mr.
Empty.
Learn counsel for the petition. Mr. A. Kalita, learn standing counsel in the sales commerce department.
Copy now,
By placing the copy of communication dated 04/04/2025 from the General Manager, Director, District Industrial Commerce Center. Semester. The
all the
calculation has already been made. It is only due to non-availability of budget for area shall be DA HRA. The payment could not be made on time. Mr. Herbert, as indicated in the communication, as in when the process for budget allocation is complete, same reflect to the petitioner in terms of the recalculated.
Yes, Lordship. In terms of the recalculation.
Recalculation. As indicated here in terms of the recalculation. However, A6 person type to place the complete instruction. A6, huh? However, A6, some more time to complete the instruction. Consider it. Considering the submission of plan extending it, let this matter be listed after 3 weeks.
That may be fixed.
Mr. The copy of the communication with the 0404 is kept on record.
I'm appearing on behalf of Accountant General. Already we issued PPO. After getting that, if the sick pay is being changed, then we have also to require to change it. Will it right? After this only our job will come. I'm appearing on behalf of section number 8 AG.
That may be fixed, my lord. So far.
See Guru, huh?
All right.
Obliged.
May it please your lordship.
Yes,
The matter relates to the regularization of the service of the petitioner, my lord.
age what?
The petitioner had been serving in the department since 1982, my lord. And his regular, he was appointed in work search APPO in the year 23/4/1993, my lord. Annexure 6, page number 23. After
May I please answer? My lord, in this petition, I applied for regulation of his service, my lord, but it is, the petition not made a finance department as party in this case, my lord. It is not made finance department as party in this case.
your lordships, the affidavit filed by the respondent number 2 may kindly be taken in your hand.
My lord, for regulation, finance department observation is necessary, my lord.
In the affidavit, my lord, in the Mongolai division, there are 3 incumbents. And among them, one of the petitioner, my lord. Tulsi Bania, Kalimuddin Ahmed and Aftabuddin Ahmed. The petitioner is Kalimuddin Ahmed, and from that letter, Mr. Aftabuddin Ahmed was regularized, my lord, in my petition, my lord. Annexure.
Your
Page number
appointment was
45,
not-
page number 45, my lord.
Your appointment was not on sanctioned vacant
Yes,
post
my
or
lord.
proper selection process.
In the similarly situated persons, Aftabuddin also in that list.
Wrongly,
Yes, my lord.
wrongly.
Yes, my lord.
So therefore, no negative equality.
I was appointed on 23/4/1993, my lord.
So
And
your
after that, your-
person has wrongly been regularized.
no, my lord, proposal was made.
See, law is very clear. Your
Yes, my lord.
regulation can be considered if you are appointed on sanction 4.
Kindly peruse page number
As
42,
per
my lord.
Pendas case, your lord.
Kindly peruse page number 42, my lord. In my petition.
You will plead the finance department will consider.
The finance department, the order was passed in the year of 2011, my lord.
Yes.
In the affidavit filed by the civil engineer, it is clearly mentioned, para number 9, 52, page number, my lord.
So, my lord, finance department is necessary party in this case.
May I be finished? Kindly, you will have the opportunity to place your submission.
Yes.
Page number 52, my lord. Affidavit filed by the.
Yes.
Para number 9, that with regard to the external matter and state that the proposal for regularization of the service of the petitioner had been forwarded to the finance department for consideration pertaining to that finance department observed that the petitioner's case cannot be taken up for consideration as the date of petitioner's engagement as work search APPO is after 1/4/1993. Hence, the case of the petitioner for regularization had been dropped. The annexure, my lord, page number 58. Page number 58, my lord. In that annexure, under Mongolai division, three incumbents were shown. All the three engagement after 1493 has dropped. 1493 has dropped. 1493 has been dropped. But your lordships will be astonished that from the page number,
Sir, your case has been rejected by the finance department.
yes, my
So
case
you
also
complete this,
rejected, and
finance
other incumbents were also rejected in the same order, my lord. But your lordship,
Learned counsel for the
your
petitioner.
lordship kindly peruse page number 40 to 45, my lord.
It
Kindly,
appears that
kindly, my
the
lord,
case of
page
the
number.
petitioner for regularization has been rejected by Department of Finance, who has not been added as party respondent here in this proceedings. Mr.
My lord, I was also rejected, and
Liberty is granted to the
other incumbents were also
petitioner
rejected, my
to
lord.
file appropriate application for implement of the finance department, government of Assam. This after 3 weeks.
My lord, I was also rejected and the other incumbent was also rejected. But in the page number 45 of my petition, my lord, kindly see.
Have you
just
implemented?
for- Yes, he was regularized, but I
So
am,
has the finance department been?
yes, my lord, he was also,
implemented?
he was also rejected, my lord. He was also rejected,
Thank you.
my lord.
Take the order. Read the order and come back. I have given a liberty you to implement the respondent number to file an application for implement of finance department.
Yes.
Thank you.
The date may kindly be,
You first file an application. We'll see.
my lord.
The petitioner filed this petition seeking a direction for seeking pension, family pension and the pensioner benefit. My respondent, my learned friend, he was supposed to obtain the instruction.
Yes.
Let's see the instructions waited. We have already communicated with the department. So fix the matter after vacation.
Immediately after the application,
Lords.
Heard Mr.
NK Kolkata.
NK Kalita, learned counsel for the police. MS.
N
next
Bora.
para.
N Bora.
M. Bora.
N.
N.
for
Bora.
Nova.
Learned
Standing council.
standing counsel for
For respondent number 1, 2, 4, 6, 7,
standing
and
counsel of what?
PNRD.
PNRD. Huh?
Respondent number 5.
And Mr. Suramsho, learned counsel for respondent number 5. Are granted for the 3 weeks time to obtain instruction.
All right.
As directed by this court on 10/03/2025. One appears for the petition on call.
My lord, the petitioner not present. I'm A Fukan, my lord.
And Upadhyay,
A Fukan for elementary education. Elementary.
that is standing counsel. This up to 4 weeks.
May it please your lordship.
Yes.
On the last occasion, the education department was asked to file an affidavit, that whether they want to file a detailed affidavit, because the rejection was on the part of the government. And director of the higher education has filed an affidavit, which is neither here nor there. So the court has asked them whether they are ready to file an affidavit or not, to that extent. That's a 2-page affidavit. They have neither denied anything.
Lawsuit, in this case, lawsuit, as does is appearing lawsuit, he's in Dixon court number 4 lawsuit. And
Yes, does.
as does.
For what? For whom?
Higher education lawsuit.
So they are the-
him, Lordship. Instruction with him, I think. Timing, Lordship.
Timing like, he's praying for timing, you know.
May I please, Your Lordship? My Lord, I was appointed as a driver of ambulance emergency service, Lordship. I have rendered 10 years of service, Lordship. Thereafter, after 10 years, one lady lost an FIR alleging 15 other persons, total 16 persons, that her husband was stabbed. I was named at serial number 15, Lordship. As the allegation was false, Lordship, I filed application before the authority seeking leave for 4 days. Leave application is here, Lordship, may kindly find at page 27.
affidavit is filed. Affidavit has been
They
filed.
have not filed any affidavit. No, deemed service is deemed to be served. So respondent number is deemed to be served, Lordship. Previous order mechanism.
Yes.
Your Lordship, I'm preparing for respondent number 3, Your Lordship. Here the appointing authority, Your Lordship, is respondent number 4 and 5, Your Lordship.
What is served?
Yes, but they have not appeared, Your Lordship.
Simple, Lordship, without adhering to the natural justice, I am terminated, Lordship.
No
I have not-
proceedings.
No proceeding, no
What is
notice
your-
was
how
given.
you are appointed?
Lordship, I was appointed by the appointment letter, Lordship, may kindly see. Appointment
Affidavit will be required, sir. Where is the appointment?
Lordship, appointment at page 23, Lordship. Sorry, Lordship, it's 16. Appointment at 16.
Offer of appointment. Huh?
Lordship, next page starts the terms and condition of appointment.
This is offer, this is an offer letter.
Lordship, this is the appointment letter.
This is the
And on the strength of this letter, I have rendered 10 years of long service, Lordship. I am not hard, Lordship, before issuing the termination letter. Lordship, they have also violated, Lordship, may kindly see page 19, terms number 12.
This is by whom? Appointment is by whom?
GBK EMRI Assam, Lordship.
Hmm?
GBK EMRI
What is that?
Assam. Lordship, appointment letter, page 16,
What is this?
middle person.
Hmm. Associate pilot.
Lordship, Sanjeev Roy, partner H. GB for GBK MRI, Sanjeev Roy, partner HR.
What is this? GBK MRI is what?
Yes, emergency service, Lordship. They
This is a government department.
Lordship, GBK is not government, they are undertaken, Lordship. The GBK EMRI provides service to the government, Lordship.
So
But regarding violation of national justice,
it's a
Lordship,
private body.
maybe national justice is applicable, Lordship, to the private body also.
It's a private body.
Yes, Your Lordship.
Private body, but national justice, violation of national justice, that is
You
there.
argue on the maintainability
Yes,
of the
Lordship.
petition against the
I am relying
private,
on, I am
private
relying
body.
on judgments also, Lordship.
private body, yes.
Yes, Lordship, private body, national justice applicable, Lordship. I am relying on some judgments, Lordship.
Not some, that one judgment where the writ lies against the private body.
Yes, Lordship. And it is funded by state, Lordship.
Hmm?
I am paid by state.
Obviously,
Yes, Lordship.
it doesn't mean that you are you falls under the authority or state under Article 12. You have been engaged by the state government. You are paid,
You are paid by the state, Lordship. I am also paid by the state.
doesn't mean that.
GBK MRI provides the manpower, but I am paid by the state, Lordship.
Paid by Poru.
10108 is a scheme of the state government, Lordship.
What is the contract between you and the state?
Lordship, 108 is the scheme of state government, Lordship.
Where is the contract between you and the state government?
That is
What is your
Lordship,
status?
that is supposed to reply by the respondent number 4, Lordship.
No, you have to first establish.
Lordship, you kindly see. Lordship, may kindly come to paragraph 11, Lordship.
Yes. Yes.
Yes, Lordship. It is clearly mentioned, Lordship.
What mentioned?
The Honorable Supreme Court, in the case of manager government branches press versus so-and-so, in AR so-and-so, has held that even in case of temporary government servant, the safeguards prescribed have to be afforded in case a penalty was sought to be imposed.
So, who is disputing that? Are you a government employee?
No, Lordship.
This was a case where the person was appointed and terminated as an Anganwadi worker under the government.
Yes.
You are not employee of the government.
But in case of temporary government service also.
You are not a government temporary. I'm asking whether the rate is maintainable or not.
Mental level, Lordship,
How?
regarding violation of national justice.
Are you the employee of the state government?
I am employee of the state government.
Admittedly,
Manpower is supplied by the
private body.
manpower
Who
is
works for the government?
Lordship, manpower is supplied by the private body, but I am engaged by the state government under the state scheme, Lordship.
When?
Emergency
That's why I
service,
said
108 to my emergency service.
your appointment.
That is, Imam Lordship, I have referred at page,
This is not by the state.
I have referred Lordship page
We are dismissing it.
16.
GBK EMR represented by
Yes.
CEO Assam Secretary
Yes.
Subham Jain, GMR Green Health Services represented by Human Resources. Where is the impugned order?
Impugned order, Lordship, page 28.
This is with reference to a letter that you are advised to provide a proper justice of your absence from your absence and while you do not inform your according to the information.
If they say that unexplained and uninformed leave of absence.
No, we're not going to that. First, you satisfy us whether this EMRI Green Health Services is a authority or other authorities or state under Article 12 of the Constitution.
But I may be given some time, Lordship.
Tomorrow.
Not tomorrow, after vacation, Lordship.
Had Mr. So-and-so learned counsel for the petitioner. The page 28,
Lordship.
challenge
Yes, Lordship.
made in this petition is to the order dated, letter of termination dated 12/05/2022 issued by the one Dipankar Das, head HR of EMRI Green Health Services, respondent number 4.
Lordship.
Respondent number 4, respondent number 5.
4, 5, 6, 7, all are.
For respondent number 4, 5, 6 and 7.
Yes, Lordship. All are for CBK हमारे Lordship.
Next paragraph. It is noticed that the petitioner was employed by the respondent number 4, 5, 6 and 7. As what? Driver?
That driver Lordship.
As driver. Or what is called? What is the appointment order?
27 Lordship. Sixth appointment letter space 616 Lordship. Associate pilot.
As associate within bracket pilot
Yes.
at level L1 in EM operations division. 16, huh? Just stop. The on the pointed query of this court, the learned counsel for the petitioner could not point out as to whether the GBK, the respondent number 4 to 6 are state or other authorities within the meaning of Article 12 of the Constitution of India. Having considered the nature of having considered the status of respondent number 4, 5, 6 and 7, I am of the prime view that the respondent number 4, 5 and 6, 4, 5 and 6, 4, 5, 6 and 7 appears to be a private body who cannot be, who would not fall under the meaning of state or any other authorities within the under Article 12 of the Constitution of India. Mr. Thus, the writ petition may not be maintainable. So and so,
He does.
for the petition.
For respondent number 3.
The on the prayer of however, on the prayer of Mr. So-and-so, learned counsel of the petitioner to for adjournment of the matter, let this matter be listed after 2 weeks. On which on the next day, Mr. So-and-so shall address the court on the issue of maintaining with regard to the status of the respondent number 4, 5, 6 and 7.
Lordship, GBK council may be shown in the clause list, Lordship. If any council is there.
Registry to show the registry to reflect the name of the respondent number 4, 5, 6 and 7 in the clause list.
Oblige, Lord.
May it please your Lordship.
Yes.
Lord, the case is ready for disposal. I'm otherwise retiring. My superannuation will be, I'll attain the age of superannuation 30 June this year, my lord. If Lordship takes it up for final disposal, my lord.
Alright, affidavit is ready, ballot sent for swearing.
The affidavit is filed already.
Nine, filed.
Filed good.
Good, sir.
It's already filed.
Motion to execute, sir. Belect the
Filed,
committee.
good.
2 and 3. It's already filed.
2 and 3 file. Oh, with that.
They filed it.
Will list up the
My lord, I'm
final
retired.
disposal.
My date of superannuation
June,
is
June,
June.
or April.
My lord, a fixed date.
Yes, sir.
What is your prayer?
Pardon, my lord.
What is your prayer? Yeah?
Prayer
What
is
is the
what?
issue?
Issue is very short and compass, my lord. I am a ex-Indian Army man.
after retiring from the Indian Army Service, I joined in the district State Sainik Welfare Board. It is a state organization. And I worked there for around 15 years. 15 years, 8 months. And I was transferred several times during my posting. And last when I was transferred from Dorong district to Hailakandi, at that time, my lord, I was suffering from certain ailments. My wife was supposed to undergo surgery, and my marriage was also fixed. So I requested the authority to stay my transfer, and because I'm supposed to retire this year, and on the verge of my retirement, they should not transfer my service. But my several representations were not considered. And then out of frustration, I said that if you give me VRS or treat this as my resignation. So they accepted it as a resignation. Now, if they, first of all, my lord, I am an NPS. There is no old pension scheme. I joined in 2008. So after February 2005, there is no pension scheme. There is a new pension scheme, NPS. So it's not like that the state would have several huge burdens on me. So it was a conditional tendering of resignation. I asked them to either to stay the transfer or give me VRS or treat it as a resignation. The law is settled on this point, my lord. If resignation tendered with a condition is not to be treated as resignation. Be that as it may, my lord. As of now, my lord, today my sincere prayer, because there is nothing left for me to cherish, even if I win this game, in this case. So I treat them to.
Then withdraw is what's there.
No. Even if this honorable court, my lord, allows me to be treated it as a VRS or set aside the acceptance order of my resignation, then, my lord, I am getting the NPS only. A few amounts that has been deducted from my salary. That is my own money. Just only thing that tendered this resignation as a VRS. That's it. I'm not claiming my salary, arrear salary or something like that.
It doesn't make any difference for you.
Pardon?
Even your resignation is accepted.
No, if it is resignation, then, my lord, gratuity and leave encashment, those things I will not get. So there are judgments of the Honorable Supreme Court, my lord. I will show to your lordship. If lordship takes it that for disposal.
Fix for hearing, my lord.
My lord may fix it for admission hearing only because no fruitful purpose will be served if it is kept pending, my lord.
Heard Mr. H. Learned Counsel for the petitioner and Mr. This is Learned Additional Senior Government.
Yes, my lord. For respondent number 1.
Admit this petition. This for hearing after 2 weeks.
Well, we fix a date, my lord. After Bihu, give a date, my lord.
It will be after 2 weeks only.
Usually view visible, automatic.
Date. 29.
That video lordship.
Yes.
This matter is relating to pension as well as I have challenged the order dated 26/4/24. Lordship, I served the department almost 34 years. Lordship. In the last part of my service life, on 7/4/22, a promotion notification was issued by the respondent number 1. And by this notification, petitioner was promoted to post of the APO, Assistant Planning Officer, and transferred to Deputy Commissioner Dhuburi. But due to my ill health, I could not join in Dhuburi district, lordship. That's why I filed 2 representation on 9/6/22 and 28/9/22. Instead of disposing my representation, the respondent authorities established a DP, departmental proceeding against me. And lordship, kindly see last page. These are the punishment. Page number 39, lordship. A, B, C. These punishments were imposed upon me. Lordship, my case is that
I have filed two representation regarding my promotion order, lordship. But those promotion order, for review of my promotion order, those were not granted by the respondent authorities. And ultimately, lordship, kindly see page number 31. Page number 31, lordship. There are four findings, lordship, findings. In the statement furnished by the Sri Hitesh Chandra Sharma on 13/10/23, he has admitted that he has not joined in his new place of posting even after being promoted. Lordship, he has stated
You
that
have received the provisional pension.
no, Lordship,
Yes.
all are withholding, Lordship, including I received nothing, Lordship. I received nothing from the department since 22/9/2022. In 22/9/2022, I have received nothing from the department, Lordship.
Lordship, first of all, Lordship, the petitioner, the order was passed, Lordship, page 38, Lordship, page 38, the order, impugn order was passed on the basis of the inquiry report, Lordship.
Yes.
And the inquiry report, Lordship, here, that the report was not challenged, Lordship. On the basis of the inquiry report, the impugn order was passed, but that report was not challenged.
I
Under
challenge
challenge.
entire things, Lordship.
No, there is no challenge. There is no challenge or have not taken any ground for any ground for any there is any regarding there is no the challenge of the report was not challenged. And
Already order
therefore-
was passed.
No,
How can I-
order is on the basis of that report. It is the departmental proceeding, and departmental proceeding, the findings comes from that report. And on the basis of that report, Lordship, this the final order was passed. But that report is not under challenge, Lordship. No, there is no prayer. No, in the pair portion of the petitioner, Lordship, there is no challenge.
Lordship, kindly see my two representations were rejected before 27 days before my retirement. Lordship. Before 27 days before, my two representations were rejected by the respondent authority. Kindly see findings, page 31, Lordship. There are four findings. Condition that he has requested the department to review the place of posting by his letter dated 9/6/22 and 28/9/22. These are my
Is it an
representations.
appealable order?
Lordship?
Is there any statutory appeal?
Yes, Lordship, he may go for appeal, Lordship.
Order 26/04/2020.
Yes. He may go for appeal against the order dated 26/4/2024, Lordship.
26/4/2024.
Yes.
Under which rule?
The appeal provision is there, Lordship.
Where? Which rule?
No, department,
Lordship, kindly.
Have you filed any appeal?
No, Lordship. I have
Well-
filed this petition. I have already retired from service, so I have prepared this petition.
that order was based on the inquiry report. It is page 31, and in the page 31, it is categorically discussed about his representation. Lordship, that report was not that report is not under challenge, Lordship. On the basis of that report, this order was passed. 38 was passed.
Already
But
published.
this
I have-
penalty is under Rule 21 of the Assam Service Pension Rules 1969.
Yes.
Yes.
Yes, Lordship.
If any order passed under this, where was the appeal provision?
No, Lordship, there is no appeal. I don't.
Appeal is No, this departmental proceeding was done under.
Okay,
Assam-
sir, I have understood.
Yes,
But penalty has been imposed under section 21 of the Assam Pension Rules 1969. Against such penalty or order, any appeal lies or not?
yes, Lordship.
If it
Appeal,
is, if it lies,
appeal-
which under which rule?
yes, appeal lies, Lordship, lies against the order passed by the Assam Service Disciplinary Appeal Rule, Lordship.
Where is it?
No, no, pension, no, appeal rule.
Yes. What do you say?
So, Lordship, this petition is proper.
The basic of this petition is that the inquiry report, and that inquiry
Oh, I
report is not under
understood.
challenge.
It's not necessary to challenge the inquiry report all the time.
Yes.
In all the situation. See, he's agreed by the penalty imposed,
Yes.
right?
Yes,
Pursuant to the departmental inquiry.
yes.
So this penalty has been imposed under Rule 21 of the Assam Service Pension Rules 1969.
Yes.
Yes.
Against that order, under which provision rule the appeal lies? You tell us that. You too.
Yes.
Yes. Yes, it's your case. Why appeal doesn't lie?
Yes, Lordship,
Why the appeal doesn't lie?
Rule 15, Lordship.
Already punishment was imposed.
So? The
No,
matter
this-
is there. Have you understood, sir?
Yes, yes.
Then
I got it. There is no bar to prepare a writ petition against this order.
are you saying that there is no appeal provision?
Appeal provision is there.
Or are you totally ignorant of the law? Please tell us, sir. Yes. Goswami Sahab,
Lordship.
which provision?
Yes, 15, Lordship. The 15A.
Of what?
This is, Lordship, the Assam Service Disciplinary Appeal Rule 1964, Lordship.
69. 64.
Against the order passed by an authority, placing him under the suspension under Rule 6, imposing upon him any of the penalties, especially. Can go. No.
This penalty comes under Rule 7.
Yes. So entitlement may, if it is against the order imposing after amendment of the penalty. Rule 7.
Hard mister,
What?
you need to have some research.
Yes, Lord. Kindly allow me provisional pension. Lord.
Pay all the entitlements
Yes,
immediately.
yes, Lord.
Heard Mr. So and so, learned counsel for the petitioner. After hearing the learned counsel for the, and also Mr. J.K. Goswami, learned counsel for the learned additional senior government advocate for the state response. After hearing the learned counsel at some length, this court finds that the penalty imposed, which is penalty imposed that is 26 by the order that by the imputed order that 26/04/2024 appears to be under Rule 21 of the Assam Pension within bracket, Assam Services within bracket, Pension bracket for Rules 1961. Which against which appeal may lie before the relevant provisions or relevant rules. Despite repeated query, learned counsel for the petitioner could not point out whether the appeal lies against the whether or not appeal lies against the said order. Rather insisting on release of provisional pension without having been, without caring to address the court on the main issue, on the issue of the, on legal issues. Mr. So-and-so, learned counsel, Mr. Goswami, learned additional senior government advocate. While pointing out the while referring to the Rule 14, 15.
Yes, 15 Lordship. Rule 15 of 15 and 15A.
15 of, where is 15A? Appeal against order imposing penalty of dismissal, removal, and reduction in bail. Pointing on Rule 15 of the Assam Service Discipline Appeal Rules 1962. Submits that appeal lies against the impugned order to which this court is not satisfied, as the impugned order has been passed, appears to have been passed under Rule 21 of the Assam Service Pension Rules 1969. And the appeal and it is not clear as to whether the appeal would fall under the under within the purview of Rule 7 of the Assam Services Discipline Appeal Rules 1964. Having confronted with such situations, the learned counsel for the parties have prayed for adjournment the matter to have proper research on the issue, as the learned counsel for the petitioner is totally ignorant about the provisions of relevant provisions of the rule. Whereas the law, Mr. Matter after 3 weeks, on the next day, the parties to address on the issue of address the issue on maintainability. Notes from the records.
I still file affidavit, Lordship.
Yes, you have filed.
No, Lordship, I need some more time.
Heard Mr. Swain, learned counsel for the petition.
Lordship, sorry, Doctor, I think some mistake has been. Item.
Item 45.
Oh, sorry, Lordship. My is 47, 57. Sorry, sir.
Yes, 45.
So file affidavit in this matter, Your Lordship.
Yes,
So we have to file a reply to that, Your Lordship.
on the prayer of Mr. Swain, learned counsel for Dr.
It's on 28.
Dr. R. Sharma.
Sharma.
On the prayer of Dr. R. Sharma, learned counsel for the petition, list this matter after 3 weeks.
On
For
28, Your Lordship.
for 5, so as to enable him to file affidavit in reply.
In the meantime, I'll file the affidavit.
Thank you.
reply.
Next.
Lordship will allow me some time to find my affidavit, my lord.
First, so and so, learned counsel for the petition. Mr. S. Gora, learned counsel,
For the
standing
BTC,
counsel,
my lord. BTC, lord.
standing counsel, BTC.
BTC.
Praise for and is granted for the 3 weeks time to file affidavit.
That may be fixed.
3 weeks.
Hello, Lord.
The matter is with regard to my lord seniority matter.
48.
Yes, my lord, I am claiming seniority, my lord, with effect from 8/4/94.
Hmm.
And they filed the affidavit showing that my seniority should be counted from 97, my lord. Now, the law in this regard is very clear, my lord. But first, lordship, I want to show the lordship my appointment letter at page 18, my lord. Page 18 is my appointment letter, my lord.
Today not possible. For disposal,
For disposal, my lord.
is there any urgency?
He taken that vote. I will retire it.
Affidavit is filed. Affidavit, they filed.
They file affidavit, my lord.
Will this
Take
come
one.
on?
He is
Will here be
retiring
some-
on.
Lordship,
30
that affidavit has not been taken that copy, your lordship, kindly that may be called for.
Where it is?
আমি ফাইল করা তো
in before.
you have filed it on
Huh? Huh? Well, he will be retiring in the month of May 31st, my lord. May,
May.
May, my lord. May I pray, my lord, within this week or Thursday, my lord.
Not possible. After vacation,
My lord, then the date may be fixed, my lord.
after Bihu. Seniority,
Seniority, my lord. But just small issue, my lord, whether it will be 94 or 97, my lord. But he is appointed, my lord, in 94. Thereafter, the post was abolished, but it cannot, he is not discontinued, my lord. So his appointment letter will be with effect from 94, my lord, not 97.
discontinued,
Yes,
or the
not
post was
discontinued.
abolished.
But it is abolished, my lord, that post.
Post was abolished,
Yes,
where you were appointed.
yes, but that does not discontinue his service, my lord.
When the
It
post
is a
ab-
continuous service, my
No,
lord.
when the post is abolished, how can there be,
No,
how can you continue?
but I'll show it from the records, my lord, that
Without the post, can you continue?
he's, no, he has been adjusted in some other post, and similarly situated person has been got a seniority from the date of joining, my lord. Lordship may see that page 61. Similarly situated person, his case has been.
What is their stand?
They didn't say anything about that, my lord.
Hmm?
They didn't say anything about that.
If that is the issue, why they have not said anything on this?
Yes, that's the affidavit they filed it, my lord.
Has
No,
Mr.
nothing explanation about that, my lord.
Has Mr. J. Roy, learned senior counsel assisted by Mr. learned counsel for the petition. MS
H Taranki, lordship.
S. Taranki, learned counsel, standing counsel, BTC,
No lordship, secondary education.
secondary education. Submits that she has filed affidavit by
On
furnishing
2/4,
the
your
copy to the learned counsel for the petition. Which, however, same is not with the reports.
But on the reopening date
Plus with
21st,
the
my lord.
reports. According
On reopening date 21st.
registry to place the affidavit in location filed by MS
21st, my lord.
H Taranki.
S. Taranki. with the record, with the writ petition. Has agreed to the counsel for the parties. This matter after
21st, my lord.
2 weeks. On 21st. 04/20.
Wait, please. In this case, my lord, the respondent number 5 had affidavit, my lord. I want to file the reclaimants.
Mr. So-and-so, learned counsel for the petitioner. First column, we granted 3 weeks time to file. Why? 2 weeks time. For filing.
1 to 4 years already filed the appeal in opposition now. My name may be shown, Malo, that I just oversight the matter.
My lord, I haven't received
Name of
UK
the,
Goswami, Malo.
next, name of the respondent number?
1 to 4.
Persona 1 to 4.
1 to, the name of the learned counsel for respondent number 1 to 4. Maybe reflected, be reflected in the poster.
May it please, my lord, I have not received the affidavit filed by the respondent number 1 to 4. I am also necessary party.
In fact, Malo, I filed earlier, Malo. Yes,
Okay, you, sir, it was the,
come later on.
sir, what's the big deal?
Malo,
What is
Malo,
it?
definitely, Malo.
My lord.
Is it so sacrosanct or what?
No, not like that. Not sacrosanct, Malo. A stand reflected reveals in both the affidavits are same, Malo.
On behalf of respondent 2 and 3, I want to find, I'm supposed to file an affidavit.
So,
So,
Mr. So-and-so, let me come. On the prayer of Mr.
yes, Mitra,
S. Mitra, let me consult for
respondent
respondent number.
2 and 3,
2 and
in the item number 50.
This matter after 3 weeks. In the meantime, parties may exchange affidavits.
51 also
Actually-
same order, 51, 50 and 51, same order.
May it please the lordship. Okay, matters are pertaining to lordship compassion or appointment lordship. Lordship only this ordinance bench has already disclosed one similar matter. I am selling the office memorandum lordship 18/9.
18/9.
Yes, lordship.
Same order. Yes, same order. Heard Mr.
Jay Hatimuria.
Huh?
Jay Hatimuria.
J.
Hatimuria.
Hatimuria,
Yes, Lord.
learned counsel for the petitioners. It's a joint petition, different.
Single.
Okay. And also heard Mr. B. Deuri,
Yes, sir.
learned state council.
G,
State council,
I am for respondent number
learned government advocate
Mhm.
for all the, for respondent number
1, 3, and 5.
1, 3, and 5. And Mr.
B Talukdar.
B. Talukdar for respondent number
Respondent number 4, 5. 4 and 6.
2 also.
Pending counsel eliminated.
Eliminate 4, 2, 3. 2, 4, and 5.
My lord. 2, 4 and 6, my lord.
This is. Next pair. Challenge means in these repetitions is to the office memorandum dated 18/09/2024 issued by the Commissioner and Secretary to the so-and-so, same that you have drafted. I say that. Then with respect to personnel B department, whereby a decision has been taken that no cases shall be no cases of so-and-so, appointment so-and-so on compulsory ground. Shall be accepted, no? Same order, no? Next order, having considered that these lead petitions involve similar issue on facts and same on heard together and distributed by this common order, huh? Just, in the next one. The case of the petition, in that set, is that it is further that Disneyland Joshi New Penny, alias Vishnu New Penny, had died in harness on 08/04/2013. Well, while serving as assistant teacher at Panamani LP School. The petitioner applied for appointment on compulsory ground. As per the relevant policy of the state. Next one. The case of the petitioner was rejected by the state level committee, against which the petitioner approached this court by filing WPC 5/4/2016, 5/4/26 of 2022. Whereby the petitioner had the whether this court pursuant to which, pursuant the order of this court, the proposal of the petitioner for appointment on compulsory ground was placed before the district level committee, Vishwanath, which was recommended for appointment on compulsory ground to the state level committee. While letter dated 02/02/2020. Next one. The respondent authorities before the consideration of the case of the petitioner by state level committee, issued the impugn office memorandum dated 18/09/2024. A decision has been taken illegally to the effect that no cases for appointment on compulsory ground shall be considered by any authority, any administrative department or authority for any reason whatsoever, nor be placed before state level committee of district level committee for recommendation of candidates for appointment on compulsory ground. Against which at least being of this hence this reposition. When you next one by one, the text you get it from each petition, which is 51 to 55. 51 to 55.
Yes, Lordship.
We are appearing for all the case.
Yes, Lordship.
Facts you can get from the each petition. In this petition, so whatever I am saying. Then you say, hence this read petition. The learned counsel, Mr.
Jay Hatimuria.
Huh?
Jay Hatimuria.
J. Hatimuria. For petitioners and Mr. B. Devi, learned government advocate. Have agreed and consented. They agreed that the case the order that is 03/04/2025 was by the cabinet bench of this court. In WPC 342/2025, within bracket, Abdul Qadir Bakshi, bracket 2, and other bunch of writ petitions squarely covers the case of the petitioner. Petitioners hearing. Next step. Having considered the submissions of learned counsel for the parties and also in the perusal of the order that is 02/04/2025 passed in WPC Shanghai and the virtual gift petition. The first we have in and review the said order that is 02. The other orders that is 02/04/2025 covers the case of the petition. Accordingly, the petitioners are entitled to be provided with the similar relief. In view of the follow, the writ petition are disposed of with the following directions. Para 9, this one. Para 9(1), don't make it the condition. Para 9(1), not 9, 9(1). Then in 11. Accordingly, we'll make some corrections here. Replace Heard Mr. Swenson, learned counsel for the petitioner. Mr. MS Arbi Bora, learned counsel, standing counsel,
BTC, yes, yes.
standing counsel BTC,
3, 4, and 5.
raised for and is granted for the 3 weeks time to file affidavit.
My lord, I may be allowed to take steps upon defendant, respondent number 6 also.
Petitioners to take steps to take fresh steps for
Fresh steps.
the service of notice upon respondent number
6.
6.
My lord, may kindly fix the date.
What is the matter?
Non-payment of salary, my lord. Next year, I'm going to be retired, my lord.
After 3 weeks, next year.
Next year, that's why, my lord.
Lordship is irregular in duty.
But
Irregular in duty, Lordship.
since 16,
Regular or irregular?
Irregular.
but there is no stop order, my lord.
We'll see.
Please, your lordship.
Yes.
This is similar as my lord, item 52 to 55, my lord.
It is a Khabar case, my lord, regarding compassionate appointment.
Lordship, let the affidavit come, Lordship. Affidavit is sent for vetting, Lordship. 2 weeks time, Lordship.
Similar,
Send it for-
absolutely similar, my lord, absolutely similar.
Challenge is what?
The same OM dated, my lord, 18/9/2024, my lord.
Yes, similar.
12, my lord, not same.
Then you just heard Mr. So-and-so learn conflict with the professional. And Mr.
A Chakraborty.
H. Chakraborty, standing counsel.
No, Lordship, I am
Government
the
advocate.
GA Assam, Junior Government Assam.
Junior,
Lordship.
learned junior government advocate for respondents.
Respondent number, Lordship, 2, 3, and 4, Lordship.
Challenge made in this situation, huh? So-and-so, so-and-so. Same one, same one. Is the prayer?
My lord, page number 12, my lord. Huh? Page number 12, my lord. First prayer.
No. Your case has been rejected.
Rejected, my lord,
By
by the
DLC.
DLC. Thereafter, my lord, due to that OM, my lord, I am barred by the,
No, you have to challenge separately. This is something different.
Lordship, that's why Lordship
prayer,
affidavit has come.
prayer number
We'll
one,
see.
prayer number one.
No, anyway, you have challenged this, I understand.
Hello.
But then you are challenging the rejection order also.
Rejection order
We'll see
also.
why you have been rejected.
My lord, page number 20, my lord.
Yes, non-availability of vacant
No,
post,
not available.
considering a case of deputation.
And
So
other,
unless we interfere that, we cannot consider.
other cases also, my lord, similar, my lord.
We'll see.
Oh,
Let the
Let the affidavit come, Lord.
Not so. Mr. So-and-so, huh? To be petitioner, Mr. On the prayer of Mr. No, Mr. So-and-so, learned counsel, learned junior government advocate. For the respondent's praise for him is granted 2 weeks time to
2 weeks
file
time.
affidavit. We'll see on
Might
next
not.
day.
Obliged.
By order. How?
64 नहीं है 64 64 अब तक काम हो ही
Yes.
जाएगा
Okay.
Lordship, I'm giving my lord an instruction which I received, my lord, from the department.
Ah.
Supposed to file their affidavit. Yes, my lord, this matter, my lord.
Heard Mr. So-and-so learned counsel.
There is insufficient budget provision, my lord, under the respective header account. Therefore, my lord, some time is sought for, my lord. Otherwise, it will be processed. In financial year 25, 24, 25, it will be, my lord, given. Budget provision under the respective header account.
Heard Mr. So-and-so learned counsel.
Main of
Mr. A. Pukhan, understanding counsel, elementary education department. Submits that he has received the instruction. For which he praised that. Praise for 3 weeks time to,
my lord, 4 weeks.
4 weeks time.
4 weeks.
File affidavit.
I'm not declaring
Praise the
for-
Lord. This, the matter approved for it in the meantime. And standing counsel to file affidavit.
My lord, instruction will be kept in the record. Sir, deeply obliged.
May I please, your lordship? My lord, this matter relating to compassionate amendment, lordship. Lordship, this is the 4th time, lordship, my case was rejected by the SLC, lordship.
Yes, Talukdar.
Uh,
SLC.
Lordship, now the grounds taken, Lordship, that I have applied after 1 year of the prescribed time limit. So
Your case has been rejected by,
SLC Lordship,
so we'll consider affidavit has been filed.
already filed. Lordship.
Okay. Not Mr. So-and-so, learned counsel for the petition. Affidavit has been filed by the state. This for hearing after 3 weeks.
All right. My lord, in this case also compassionate appointment, Lordship, the SLC rejected my case, Lordship. On the ground that, Lordship, already 3 posts already, although there are 2 Lordship posts out of 5%, there are.
Mr. So-and-so, learned counsel. Affidavit filed.
Not affidavit was filed.
Mr. So-and-so, learned counsel for the petitioner and.
2 weeks time also filed.
And.
And for a revenue department.
He got
J handicap.
J, sorry, J and J. Counsel for. Revenue Department.
Revenue department, 2 and.
Granted for the 3 weeks time to file it. This opportunity.
Obliged.
Happy Lordship.
Yes,
Regarding compassionate appointment, Lordship. But it is not rejected, Lordship. Kept for next DLC.
Huh?
Kept for next DLC, Lordship.
next
But it is
DLC.
still not produced in DLC. That's why I am.
Kept for next DLC.
DLC,
It's not rejected.
not rejected. Page 27, Lordship.
So,
Page 27, last 2 lines.
so you are not challenging the latest.
Just to
office
produce my application in next DLC.
Huh?
It is my challenge.
It is Lordship purely covered by the Devabhuta Tiwari case, as because the Lordship, his father was died on Lordship 2/5/2006 Lordship. Delay has been occurred, Lordship.
In our High Court.
Affidavit is filed.
Not so, no, affidavit has not been filed.
Mr.
Lordship.
So-and-so, learned counsel for the.
Eight challenge.
Mr.
A Chakraborty appear for respondent number 3, Lordship.
Para 9 is covered, Lordship.
Request for in granted. 2 weeks time to file affidavit.
Lordship.
Let them file the affidavit. We'll
Lordship.
If it is filed.
No, Lordship. Not filed, Lordship. Not filed. Not filed, affidavit not filed. On behalf of respondent number 3, not filed, Lordship.
You're confused with some other case.
Another case.
Obliged.
Them,
It is also similar, Lordship, kept in next DLC.
yes.
But affidavit is also filed, Lordship.
Yes.
Here affidavit filed, Lordship.
What is your ground?
Okay, here respondent number, Lordship, 3 has filed one affidavit in opposition, Lordship. Here, para 6, Lordship. May I read, Lordship? That with regard to a statement made in paragraph 5 of read petition, the answering deponent state that as per record furnished by the SP Hailagandhi on 27/5/1995, the OC Lala PS, as per instruction of the SP Hailagandhi, intimated that mother of the petitioner Srimati Gopa Chakraborty, wife of late Hari Prasad Chakraborty, to submit particulars consideration appointment immediately. However, there is no record in this office suggests the name of Sri Gopa Chakraborty as the mother of the petitioner did not submit any application, Lordship, for appointment on compensation ground to respondent number 4 during the period. Moreover, it is mentioned that no grade 4 post was vacant during that period, Lordship, and there was little scope to consideration of appointment of grade 4 post as per produced relevant at that time, Lordship.
It's Alamgiri. Learned counsel for the petition.
Post was not vacant, Lordship.
Affidavit has been filed.
Respondent number 3, Lordship.
Post was not taken, that's why it is kept.
Is the matter for hearing after 2 weeks.
Homeless.
Yeah, please.
Yes,
Malad, this matter malad become infractions malad. My creditor was rejected by the SLC on 24/1/2025, which was I have already challenged malad before this honorable court.
it has become enforced.
Yes, therefore malad this.
Hard, Mr. So-and-so, not hard, Mr. So-and-so. Name please. D. Gogoi, London Council for the Petition submits that the writ petition has become infectious. Mr. So-and-so, getting some level of essential to the minimum. It's good. India bill, writ petition still dismiss as infectious. Secondly, you have so many, you have so many orders to be typed over. You may go send somebody. Anybody is there. Yes.
May I please, Your Lordship? Well, Lordship, in this matter, the conducting counsel is out of session, Your Lordship.
Then
Due
why
to-
this has
due-
been listed in the supplementary clause?
Due to some urgency, Your Lordship, he has to left, Your Lordship.
Mr. So-and-so, learned counsel for the petitioner, submit that learned arguing counsel, Mr.
R.A. Chaudhary.
R.A. Chaudhary is in this post today, for which he prays that matter may be listed after 4 weeks.
Similar prayer with regard to 70, 71, 72, 73, and 4, Your Lordship.
Similar order.
Yes, Your Lordship.
What is the matter?
Yeah, compassionate, Your Lordship. Similar prayer, Your Lordship.
What is the prayer?
Your Lordship. Lordship, I am praying for adjournment, Your Lordship.
What is the matter I'm asking?
Matter relates to compassionate appointment, Your Lordship.
Challenge of the notification law, 2024 notification.
Challenge the notification.
Notification laws.
Same,
Same.
18-9.
Lot.
Covered by judgment.
Same order. You are disposing.
By,
It's a covered case.
yes, Your Lordship. Covered by the judgment, Your Lordship.
Dispose.
Send it to the approved.
Not Mr. Your name, please.
R.A. Majumdar.
Hari Majumdar, land council for the petition. Facts, huh? Similar, challenge. This is from 70 to 74.
72,
74.
74.
Different facts. Share with Anamika. Both you jointly and right? Facts will be. No, dispose of. The same, similar. thing. Unnecessary why I should keep it pending.
Not
70 to 74.
Oblige. টাইম হেৰি কৰিব বোলে কৈ দিয়ক কথাটো মই কৈ দিম taken out after vacation in India will file our additional affidavit also.
What is it?
Your Lordship, we are claiming a pay parity with our juniors. In spite of it being similarly situated and having the equal qualifications, they have still the march over me in terms of pay. Since I joined the
What
service,
is the post?
Your Lordship, I retired as an associate professor.
Why additional affidavit?
Your Lordship, what happened is that the government has rejected my case.
Okay,
So the director has filed the affidavit, which is neither here nor there.
Okay.
So the government has to file the
But
affidavit.
Mr. Arsinger, learn counsel for the petitioner. On the prayer, Mr. So-and-so,
SBI,
learn counsel for the
higher education, 1, 2,
the standing on higher education, standing on higher education. Press for and is granted further 3 weeks time to file additional affidavit.
Your Lordship, the affidavit will be filed by the government, not by the directorate, I suppose.
Secretary. Huh?
Secretary.
Secretary,
And in finances filed an
you are
affidavit.
representing the secretary.
Yes, Lord. And your Lordship, the finance department has filed the affidavit. But my office has checked the records. This affidavit does not tally with the affidavit filed therein. So they have requested the counsel of the finance department. No, my office has been calling them since a long time, but they have not done it. So this practice should be stopped.
You please be honest.
And I have,
The clerk has given. It's okay.
no, he was also said, your
Don't make
Lordship.
an issue. Say, your colleague.
Yes.
Don't be.
Lordship, that is not the issue. My
It's
office
okay.
has called him also.
It's okay.
Yes.
Don't involve, we're not interested in it.
This practice
If
should
there
not be
is-
done,
Okay.
your Lordship.
Why should record unnecessary all these things?
No, I'm not
It's
saying
not
that,
down, it's
but
okay.
they should provide a copy. Since
Yeah.
morning, they have
You
been asked to provide a copy. They are not providing it.
It is submitted by Mr. Arsinger, counsel for the petition that the copy of the affidavit filed by the finance commissioner. Finance department is not telling with the
Copy filed before the honorable
the
court.
affidavit filed in the, before the court. In view of the work, Mr. H. Ali Leonard is telling us for finance department to furnish the copy of the affidavit of opposition filed before the court to the learned counsel for the petition within 2 days. You must be having, get it done in.
Lordship, I'm appearing for UGC respondent number 4.
Ah,
Lordship, it may be recorded.
I'm appearing for respondent number 6.
but you filed the affidavit,
Yes, deeply obliged.
this after 3 weeks.
May I please hold office. Office note reflect the services complete manner. And respondent number 3 has filed affidavit, but respondent number 1, 2, and 4 has not filed affidavit.
Yes,
Lordship, I'm appearing for the GAD department. We have received the instruction, we'll be filing it. I don't have it after the vacation.
My lord, I am appearing for respondent number 4 in both the writ petitions. I have filed affidavit in one and another. I need some more time. Then in item 59, I will have to file.
heard Mr.
And hotline.
Counsel for the petition. And Mr.
A. Fukan for respond 1 and 2.
And.
I am for,
On behalf of 3 lords.
I am
What is the-
RS Club on behalf of respondent number 4 in both the writ petitions.
And who is for 5? Nobody.
5 and 6 were service complete, they have not.
Private manner, they have the service not completed.
Complete office note reflects.
Nobody has been present.
It's okay. Respondents are granted 3 weeks time to file affidavit.
Applies.
Petitioner herein, my lord, he is one of the wife of the, my lord, deceased employee, government servant, my lord. Here, what happened, my lord, the husband of the, my lord, petitioner, my lord, have 3 wives, my lord. One of the wife,
Why review? What's wrong in here?
my lord,
What's
here,
the
the case is,
typographical mistake?
my lord, here the case is, my lord, the earlier writ petition was filed by one of the wife of the petitioner's husband, my lord, claiming the family pension of the government employee, my lord. Now, in that writ petition, my lord, the petitioner and the other wife, my lord, they were not included as parties, my lord. In the writ petition, they suppressed the material fact and, my lord, they filed the writ
It's
petition.
okay. The direction is what?
Direction is for consideration of the representation, my lord. That representation was
Even the petition files and everything provided the respondent authorities. Principal petition shall consider and dispose the application within 3 months from the date of receipt of the application.
yes. So, my lord, for consideration of the representation, the writ petitioner filed the representation before the authorities for sanctioning the family pension. and the retirement benefit, my lord. The deceased, the husband of the
You are not a party to,
not party. Even I was not implicated as party in the writ petition. So, my lord, not only myself, the other wife also. Total 3 wives are there. Government employee had total 3 wives.
so you have taken a leave to file review.
Yes, my lord.
You are not party in the writ proceeding.
I'm not a party in the writ proceeding.
So how can
So I-
you,
no,
how
my
you
lord,
can
already-
straight away file a review?
I filed a leave application. That leave application already has been allowed by this court, my lord.
Okay,
Only
That's-
after-
that is why I'm asking.
My lord, after leave application was allowed, my lord, this review was registered, my lord. Now the
What is
question is
petition?
here, my lord,
You
here
are
the
for petitioner.
I'm for the respondent BTC.
No, no, indeed. So,
no, my lord, writ petition has not yet been issued notice, my lord. Today is the, my lord, first date of
Review.
review, my lord. So, my lord,
heard Mr. So and so, then counsel for the petitioner. Review petitioner,
review petition.
issue notice to the respondents.
Yes, my lord.
What is this, what review should be passed here?
No, my lord, here only the case is,
No. With the petitioner in this, in the earlier writ petition,
my lord,
Jamila Bibi,
no,
she is also a wife.
he is also a wife, my lord.
So,
Total 3 wives. All the wives have the same claim over the family pension of their deceased husband.
yes,
Now, without implementing the other wives, one of the wives came to this court,
Jamila
suppressing the
Bibi,
fact, suppressing the material fact that the government employee had 2 others' wives. Now she filed a representation before the authorities. This court, my lord, directed the authorities to consider the representation. Now, supposing that the representation has been considered by the authorities and the family pension and entire, my lord, gratuity and the retirement benefit is released in favor of the wife, my lord, the petitioner, writ petitioner. Now, the present petitioner and the other wife who are not parties in the writ petitions, ultimately, my lord, they will suffer, my lord. They will deprive from their
so it will issue notice.
notice, my lord. At this is just notice, my lord.
Heard Mr.
MA Islam, my lord.
Then counsel to the petitioner, review petitioner. Next paragraph. This is an application for review of the order dated 29/05/2024, passed in WPC 2741, 2024. Issue notice to the respondents, huh?
My respondent writ petitioner, my lord.
No, all of them,
All of them, my lord.
respondents. How many respondents?
My lord, total 8 respondents.
Respondents.
Not 8, my lord.
9. 9 respondents.
9, my lord. 9.
Respondents. Then in this case, who else will appear?
I mean, respondent number 6, page 4.
Serially, State of Assam, Commissioner Secretary, Government of the PNRD. 2 and 3. Since Miss MS Swainsu. Standing Council. PNRD chief.
I appeared on behalf of 4 rows. Pension and public events.
And
Respondent number 6.
Swainsu, respondent number 6. And
I'm appearing for respondent 8.
8. Commissioner. District Commissioner.
More, sir. 6.
Accountant General.
7.
BTC.
7, 8, 9.
BTC. Appears and accept notice on behalf of respondent number 1, 2, 2,
7.
3,
My lord, 7 and 9.
4, 6, 7, 8, and 9.
The 8 notes I am appearing on behalf of.
Yes. Are appears and enters appearance and accept notice on behalf of friends, yeah. 2, 3, 4, 5, 6, 7, 8, 9, and 9. Huh? No formal notice need be served. However, extra copies be furnished to the learned person to the commission. Learned person to the response. Next paragraph, petitioners to take a step for submission notice that on respond number 1. My registered person for solution. List after 4 weeks.
My lord, there's the interim period, my lord, during pending of the review petition, so that, my lord, the authorities, my lord, they should not consider
They'll
the,
not do it. 4 weeks, we'll see.
there is an interim period, that
It's
may be
okay.
considered.
We'll see, we'll see.
Let me make a submission. In the review petition, I am for respondent number 6, accountant review.
No, that's
Yeah,
okay.
correct.
All the
And one more preamble, you may give us extra copies of the leave application as well as the.
leave already granted.
Yeah, that's.
I've directed him. Yes.
Right, yes, leave it.
All right.
Wait, please, your lordship.
Yes,
This is for implement of the party lordship
yes.
as respondent number 4 lordship.
Yes.
Principal come secretary of the women's college lordship. In the writ petition inadvertently, even I typed it inadvertently, I don't know, somehow not saved. So it has been not there in the writ petition. So for
Yes,
that,
any objection? No. Her Miss MS. D. Ghosh, learned counsel for the applicant, public writ petitioner. Writ petition, applicants, writ petitioner. And also had Mr. And
Akita Gupta on behalf of AG.
For the respondents. This is an application for praying for implement of the principal from secretary from a women's college. Kilser, son, as respondent number 4 in the connected writ petition being WPC. No, in the connected WPC 116 for 2020. Next one. It is submitted by the MS Legos and council to the applicant. The principal from secretary from Women's College Kilser is a necessary factor. Which has been inadvertently not been added as party respondents in the connected with petition. In the connected with petition 116 for 2024. Therefore, president. And then president the principal from secretary from women's policy may be allowed to be included as respondent as the principal from secretary is a necessary part. Learned counsel for the response from the semester, they had no objection for implement. Implement, Mr. Implement as per applicants. Having considered that they consider the submissions of learned counsel for the parties. And also considering that the principal from secretary women's college Kilser is that is to be necessary party in the connected WPC 116 for
lordship.
accordingly, the principal from secretary women's college Kilser be implicated as respondent number 4 in the connected with in the WPC solution. The highest spoken
I'll file amended cost title lordship.
in writ petition
Writ
in view of the order passed when suspension. The learned counsel for the petitioners to file the amendment to file amended cost title. Thereafter, the registry to incorporate the newly implemented respondent number 4 in the
Lordship, interim order is there, it may be continued, Lordship.
Interim order. A notice has to be issued.
Yes, notice is issued since that chronology is not maintained, Lordship. I had submitted all the copies before the,
But then when
registry.
that implemented and the
If-
registry to, thereafter registry to incorporate the name of so-and-so, responding. The petition is to take steps for service of notice
Yes,
upon respondent, newly implemented respondent for, after incorporation. In the.
I'll file first amended cost title, thereafter.
Yeah, that directly.
Yes, Lordship.
Interim order for the election coming. After 3 weeks, list of 4 weeks.
Yes. Deeply obliged, Lordship.
May it please, Your Lordship. Your Lordship, in regard to item 50 and 51, there is an interim order. Your Lordship, I forgot to seek for.
51, interim order.
Much obliged.